right, we are live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to this sitting of the Massachusetts Appeals Court. I'm Justice Wolahojan. With me are Justices Desmond and Grant. Although we're sitting in that, we're hearing this case in this format because of the ongoing pandemic. Although we are conducting court in this format, all the ordinary rules of our court apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the first case on our list this morning, which is Commonwealth versus Julio Torres, case number 2020P0063. Attorney Tenon, we are ready whenever you are.
Thank you. Good morning, Your Honor. Good morning, Your Honors. Eric Tenon on behalf of Mr. Torres, and if it please the court. This is a case about what record is needed to justify a continued search via GPS imposition as a probation condition. And really the issue is just because a condition was reasonable in the constitutional sense when imposed doesn't mean that it's reasonable forever. And because circumstances change and because whether something is reasonable in the constitutional sense can change over time, the justification must persist if the GPS is going to continue to be imposed as a condition. Let me just start by saying I know this case has a really odd and tried procedural history. I don't know if the court has any specific questions. I wasn't planning on going through it, but if there are, please let me know. But if not, I'll just...
You should both understand that we have read your materials thoroughly. So
I know that, but this case is just odd in terms of how it's been back and forth and all the stuff. So I didn't know if there were specific questions, but it's okay. So when this motion was brought, the defendant had been out on probation for about 2.5 years, and the court is familiar with his background, having what he's on probation for, and then having gone through the civil commitment process, which sort of extended his sentence a little bit, and then coming out from that and starting probation. The GPS had been imposed long before that, so never really through this lens of Fourth Amendment reasonableness, but nevertheless, when he was released, the conditions were in place.
When you say that GPS was imposed long before that, I take it what you're saying is the condition of GPS was imposed before that. The GPS itself had not been imposed before then.
Yes, that's correct. The condition was imposed back in 2007-ish when there was some sort of when there was a re-looking at his case because of a probation issue back then. But it didn't get imposed until he actually left, which was in 2017, January 2017, when he got released.
Well, wasn't he wearing the GPS in 2009 when he committed the annoying and accosting?
No, yes. So it had been imposed back, the condition had been imposed back then, and then he had been out on probation for a little bit with the same conditions in place back then.
Wearing the GPS.
Wearing the GPS is my understanding, yes. So, I'm just talking about the imposition of the condition. It wasn't a new imposition back then. It had already been issued as a condition. So when the judge issued it as condition, it wasn't seen through the lens of Felice and Johnston and the Fourth Amendment. It was just imposed as a condition. And actually back then probably imposed as what they thought was a mandatory condition. That was even before those cases. Nevertheless, we now know after Felice and Johnson that GPS, no matter when imposed, is a search in the constitutional sense and must be reasonable. There must be an individualized determination of reasonableness.
Do we review for de novo, or do we review for abuse of discretion? Given our review on reasonableness, we're looking to see what Judge Sullivan did.
I think I cut all your question. I saw your mouth moving after I heard the voice, but I think your question is, what's the standard review given what Judge Sullivan looked at?
Right.
Okay, so it is de novo because you're doing a constitutional review. You're reviewing whether the condition is reasonable in the constitutional sense at the time of the motion. I will say that. There was no fact finding. Sometimes there might be fact finding, but there's no fact finding in this case. So you essentially have the same record that the judge had below, who, by the way, was not the sentencing judge. So when you're doing when you're asking whether something is reasonable, whether a search is reasonable, that's always de novo.
What is your best case for that proposition, that that's the standard of review?
It's every search and seizure case. The court, in terms of legal arguments, whether something is reasonable is a legal argument, and the court always does a de novo review of that. Sometimes in cases there are factual findings, and you would have to defer to the factual.
I mean, this is slightly different because unlike many types of search and seizure analyses, this is actually a balancing of factors, correct?
Absolutely, but factors
right.
that.
So a balancing of factors, I don't know of any situation, but maybe and you will correct me, no doubt. I don't know of any situation where balancing of factors is reviewed de novo as opposed to for abuse of discretion.
I think it's in these types of cases.
That's why I'm asking you for a case site.
I don't have one off the top of my head. I think the best answer, the way to look at it is, a lot of search and seizure cases are balancing cases. And once the factors are, once you know what factors you're balancing, so again, if there's fact finding, you defer to that. But once you have it set out, okay, these are the things we're looking at. This is this condition, this issue, that issue, etc. Once that is there, a court, an appellate court, always does a de novo review of the legal analysis of that. The balancing is a legal analysis.
Why doesn't this fall under the line of cases that where we review whether a particular condition of probation was reasonable?
Because this is
we understand that GPS carries with it constitutional considerations, but nonetheless, why doesn't it still fall within the rubric of determining whether it was reasonable to impose it as a condition for probation?
Because when you look at reasonableness of probation conditions, it's a different standard than when you look at whether something is constitutional. Whether
I understand that, but it would help to find cases, if you could tell us cases that say that when we look at this, we don't look at it in the probation context, but rather in some different constitutional framework.
I tried to see if there were any cases that talked about Felice through a lens of years later. And as far as I can tell, there's not. There's obviously Felice and Johnson, which themselves reviewed the imposition of probation conditions, themselves did the constitutional analysis and said, was this condition constitutional when imposed at sentencing? And the appellate courts, the SJC itself, did the balancing and said, this is reasonable or not reasonable. There was a subsequent case after the briefs were filed, Garcia versus Commonwealth, was just about a stay of GPS imposed as a stay of sentence, as a condition of a stay of sentence. Again, the SJC. Again, the issue was whether it was reasonable when imposed as a condition. Again, the SJC doing that balancing and looking at it whether it's a reasonable search. And then there's just an unpublished decision of this court, which again was looking at whether it was reasonable when imposed. So there really is nothing that talks about how to look at it later, but at least Felice, Johnson, Garcia, the SJC itself did that analysis and said, this is or is not reasonable, this is or is not a reasonable search, and the condition should or should not be imposed. So this case is important in that sense, because as far as I can tell, and I'm sure your honors and your clerks can do the research too, there is nothing that talks about what to do a couple of years later when there's a contention by a party that conditions have changed or it's no longer reasonable.
But you're alleging, aren't you, that when Judge Sullivan did his review, his determination was unreasonable, that he didn't balance the factors appropriately, is your argument, and thus we should reverse him. So don't we look at the factors that he balanced? Did he apply them appropriately?
Oh, absolutely, Your Honor. Sorry, it happened again. I'm not saying that you don't look at what he looked at. I'm just saying that you, the appellate court, balances those factors yourself to decide whether or not the condition at that time of the motion or at the time that Judge Sullivan decided it was still a reasonable search. So 2.5 years plus into probation, where the condition at that point remained a reasonable search, as opposed to when it was imposed and when the defendant was first released from incarceration.
Are you arguing that every time GPS is imposed as a condition of probation, even if it's imposed, even if it's reasonable when imposed, that calculation is entitled to be revisited throughout the term of probation?
Absolutely, because it's constitutional, because we're talking about an ongoing search. The government can only conduct a search like this if it is reasonable, and that can change with circumstances. A search once reasonable can become no longer reasonable.
So do you have a case for that? Do you have a case that says we do this over and over and over again?
Again, not in the GPS context, but there are cases that talk about how searches at some point can become unreasonable over time. I cited two.
Sure, but I'm looking for specifically GPS, because I can't see a limiting principle to what your argument is. Does it mean that every day of probation, the probationer could move to have the GPS removed, and that the judge would have to do a calculus of rebalancing every day?
I suppose in theory, but not really. I mean,
okay, so what is the rule that you're asking us to adopt?
I mean, it's not practical, but in theory, they could do it every day, because the rule is whether the search is reasonable at the time it's being done. And
which is when it's imposed as a condition, no?
No, because the GPS search happens every day, right?
Yeah, but doesn't the cases tell us that you have to show some type of a material change if you want to have it reviewed, or even the government has to show a material change or a violation of the probation? Aren't that what triggers the review?
That is for a probation condition. This is where the standards of a probation condition are different than whether something is a constitutional search.
But aren't we talking about a probation condition right now?
It's tricky. We are. I'm sorry, Your Honor, if I'm cutting you off.
No, there's a time lag, and we're aware of it.
Okay.
Sorry.
This is tricky because there are most probation conditions have no constitutional implications whatsoever. And so those conditions need to be reasonable. I mean, there's some limitation, and they have to, be applicable to the person. And if you're going to change, though, there has to be a material change, like you say, Your Honor. But when you're talking about a condition that has a constitutional implication, it's different, and you don't apply the standard review of whether the probation condition is reasonable when you're talking about whether something is constitutional and remains constitutional.
What if it was a probation condition that implicated a different constitutional right? Like, for example, what if it was a condition that the defendant can't write a screenplay about the crime, as in Power? Would you be saying that that needs to be revisited periodically every time, new cable Netflix is invented, or new avenues for making a movie are invented? Or every time he writes a new screenplay, the judge has to have a de novo hearing?
That's a different kind of constitutional right that you can interpret at one point and can be good forever, versus a search which can change over time. The standard review for you can't profit of it is not reasonableness. The standard review for whether something is a constitutional search in this sense, this sort of ongoing search, is reasonableness. So some things do warrant review because circumstances can change whether they are reasonable things. Some things do not.
Can you go back to Justice Desmond's question, and in some ways mine? What is the limiting principle on how frequently this gets redone, if it's not what Justice Desmond, the circumstances Justice Desmond enumerated, including a material change in circumstances?
I mean, there are practical limiting principles and then legal limiting principles. Legally, I don't think there's a limiting principle in that. Yes, at some point, I think searches can become unreasonable, and at some point it tips over, and so you can challenge it until you get to the point if you think it has tipped over. I don't think there's anything that prevents a party from saying, okay, today's the day. Practically, we know that's not realistic. You file a motion and things take time to go through, and you're not going to file it on day 2 because not much has changed from day 1. But in theory, yes, something because of the kind of analysis it is subject to be reviewed whenever the party can show that things have changed so that the search is
okay, so you are pointing to some kind of change in circumstances, because otherwise, why is it that we don't just assume that when the judge initially imposed the condition, he or she was taking into account that unless nothing changes, this is reasonable every day for every day of the defendant's probationary period?
I don't disagree with that, Your Honor, and I didn't. In the motion that was litigated, it wasn't, what we put forward was things have changed at this point. Now that you have his record of probation, it's no longer a reasonable search because of A, B, and C. So I wasn't staying in the record at the time. And in fact, I think that's the problem with the Commonwealth's argument and Judge Sullivan's analysis, that they were only looking at the record at the time of imposition versus everything that had changed. So it is still the burden of the party, of the parties to say it's reasonable or not. The Commonwealth still has the burden to show it's a reasonable search at that time.
All right, we have your argument, I think. Let me see if there are any further questions.
I just have one other question factually. At the time that Judge Sullivan heard the matter, I believe Mr. Torres was still living in a shelter, but had or was about to transition perhaps into a month-to-month lease. Did he indeed transition, or is he still in the shelter?
I can answer that question. I'm not sure if it's on record, but he did, and he did transition. He's not in the shelter, and he wasn't at the time that Judge Sullivan decided it, because that was part of the supplemental record. It happened in between filing the motion and supplementing the record, but before Judge Sullivan decided it.
Thank you.
Thank you. Attorney Sherman?
Good morning, and may it please the court, Catherine Sherman on behalf of the Commonwealth, asking this court to affirm the motion judge's ruling. Beginning with the question that your honors have already posed, this is to be reviewed in an abuse of discretion standard. Not only, as the court has already pointed out, is this a balancing test review, it is also a condition of probation, ultimately a sentencing decision that this court is reviewing, which is well established to be an abuse of discretion standard. Judge Sullivan did not abuse his discretion when denying the defendant's motion to remove his GPS. The information in front of Judge Sullivan at the time of the motion was not only properly considered the defendant's record and history leading up to the imposition of GPS probation, but what had occurred between the imposition of, or the attachment of the GPS in 2017 and in 2019, when this was before Judge Sullivan. He had additional information that lended credence and bolstered his ultimate decision, including those opinions issued by the qualified examiners and the history that they detailed, as well as the defendant's level 3 SORB classification, which was important to the balancing test here in terms of the reasonableness on the intrusion of the defendant's privacy versus the Commonwealth's interests.
Do you think that the length of time for which GPS is imposed is a factor that should be considered in the reasonableness of imposing GPS as a condition of probation?
I think it's a factor that can be considered when, in circumstances like these, a judge is reviewing a motion for a change of probation conditions. As the court alluded to, there may be a material change of circumstances that makes GPS no longer reasonable for a defendant. And that might include something like an extended period of time during which a defendant has been monitored successfully and shows signs of rehabilitation that make GPS no longer as vital to protecting the Commonwealth's interest as it might have been at the time of imposition. The case before the court does not pose those circumstances.
So why not? It appears that his last infraction before he was released had occurred maybe 4 years before he was released. He's now been out, as I understand it, I think maybe 2.5 years. So we're looking at a window of approximately 6.5 to 7 years without incident. Why isn't that not a material change?
I think at best we're looking at about a 2-year window without incident. The time between him being released from SDP civil commitment and the time at which he brought this motion before the court. During that approximately 2-year period, though it is fair to say he did not have violations of probation during that period, he was living transiently. He presented the court as the material change of circumstances to be a potential future lease, which was only a month-to-month commitment. And that was really the only change in his circumstances. Judge Sullivan properly considered how, as the court has pointed out, this defendant was monitored on probation at the time he committed a sexually explicit, annoying, and accosting of a child. He was in a permanent house at that time, living in a long-term relationship with family members. And leading up to that, he had committed violations of probation, I believe, 3 times for failing to register as a sex offender. So even with just those considerations in mind, it was still entirely reasonable for Judge Sullivan to consider the need for the ongoing GPS monitoring of this defendant.
In your words, what are the purposes of GPS monitoring as a condition of probation?
GPS monitoring serves a deterrent value and a rehabilitative value, as well as a public safety. It's also a public safety tool. So considering this as a deterrent tool, probation alone did not deter this defendant from committing the sexually explicit, annoying, and accosting. Prison did not deter him from committing additional sex offenses. His qualified examiner's report explained that he had sexually assaulted another prisoner in jail. He had possessed pornographic materials, and he asked another prisoner to violate a restraining order on his behalf. And as, again, related to deterrence, the qualified examiners described his sexual offenses as repetitive and compulsive. He needed strong deterrence to prevent future sex offenses. The qualified examiners and the defendant, in arguing for his release from sexually dangerous person commitment, placed a lot of value on the GPS monitoring as a tool for rehabilitation and reintegration into the community. A lot of value was placed on that by both the examiners and the defendant himself. And as far as the public safety concerns, this is a defendant who was assessed as a high-risk potential future offender. He was given the level 3 SORB classification. He had a history of failing to register as a sex offender, had a history of violating court orders, including restraining orders. And there were variations in his offenses that the qualified examiners described as having no common theme. So this GPS tool is not a hypothetical, or this GPS monitoring serves a potential law enforcement purpose should he need to be investigated in the future. And in all these ways, that makes this defendant completely different from the defendant in Commonwealth v. Feliz.
And so one of the things I thought that the record revealed was that, yes, he offended against, I'll say an adult, and he also offended against a child, I believe. And I think I read that he had a special desire toward post-pubescent young girls. Is that in the record? Did I read that properly?
It's certainly in the record that he committed sexual offenses against both adults and the sexually explicit offense against a child. I don't recall off the top of my head if the qualified examiners had had articulated that sexual impulse, though that would be consistent with their finding that there was no common theme among his sexual impulses.
So would you agree that the strongest prong that the government's looking to for this particular defendant, because the GPS has to be particularized for this particular defendant, is the public safety?
I believe that and the deterrence, yes.
And so how does it work for deterrence? I mean, he doesn't have any exclusion zones. So here's an offender who offended while on probation. Like you say, it offended while in prison. So what makes the GPS have some type of deterrent value?
And, you know, in light of your Honor's question and the way that you've posed it, I suppose it does work hand in hand with the public safety value of the GPS, knowing that he is monitored, his location is known to the Commonwealth. Should he commit future offenses, that is strong evidence against him. And I believe it was in the qualified examiner's reports that they described this defendant not understanding the severity of his offenses and his situation until he was committed as a sexually dangerous person. So he's now out of that SDP commitment, knowing the potential consequences should he reoffend, should he be prosecuted again and potentially civilly committed. So he does have a different lens through which he's operating with this GPS monitor.
Part of an earlier answer you gave concerns me a little bit. You mentioned that the GPS, part of the purpose of the GPS is to serve as an investigative tool in the future, so that essentially it would help with a future investigation if the defendant did something. I'm sitting here wondering whether it's permissible to impose as a condition of probation something that would constrain the probationer's liberty simply to help the Commonwealth in future criminal investigations. And I'm not thinking that would be right. How about you?
No, if that were the only purpose or one of the few purposes for imposing a GPS, it certainly would not be. In this defendant's case, it's one among a litany of reasons why the imposition is reasonable and why the privacy intrusion to the defendant is outweighed by the Commonwealth's interests. And if there are no further questions, I will rest on my brief.
Let me check. I think we understand you. We have your argument. No, I don't see any questions. Thank you both. It's an interesting case. We've been benefited by your argument and by your briefs. So we appreciate that and thank you. And the case is now submitted.
All right, we are live and recording.
Good morning and welcome to this sitting of the Massachusetts Appeals Court. With me today are Justices Desmond and Justice Grant. My name is Gabrielle Woolahojan. Although we are sitting in this format due to the ongoing pandemic, all the ordinary rules of oral argument in our court apply, including that each side gets 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus Scott, 2019 P0287. Attorney Nguyen, we're ready whenever you are.
Your Honor, I think it's myself who goes first.
I'm so sorry. Attorney Nguyen, would you please put yourself on mute?
Certainly.
To help me. And Attorney Scapicchio, I'm so sorry about that. Of course, it's you.
No worries, Your Honor. Thank you. Good morning, Your Honors. My name is Rosemary Scapicchio, and I represent Guy Scott in this appeal. There are two issues that I'd like to discuss in my 15 minutes today. One is the juror issue, and the second one is the restraining order issue. With respect to the juror issue, the trial court in this case, by deputizing the foreperson as a caretaker for another deliberating juror, created an unequal relationship in the jury room that resulted in a violation of Mr. Scott's 5th, 6th, and 14th Amendment rights under the U.S. Constitution, as well as Article 12 of the Massachusetts Constitution. And that is because Mr. Scott had an absolute right to have a jury, an impartial jury, and a juror that was not affected or overly influenced by anyone else. In this case, what the trial court did is it received a note from a juror that the juror was having some trouble, that the juror had reported to an emergency room, and that the juror had indicated, at least to the emergency personnel, that she was going to jump out the window if she had to further deliberate. This is the same juror who 2 days prior had had an anxiety attack in the courtroom, and it was visible to all of the parties and put on the record as part of what her personal circumstances were with respect to her jury deliberation duties.
Attorney Capiccio, didn't the hospital or the nurse send a note that permitted the juror to continue to sit?
Well, I don't, Justice Esmond, I don't think that the court permitted the juror. I think I think what the hospital note did is say, this is what happened, and I'm going to leave it up to you, the court, to determine what should happen as a result of it. So it was more of informing the court that she came, that she had some difficulty, that she was evaluated psychologically, and that she was cleared psychologically. But that's not the whole problem. The problem here is the appointing of the foreperson as a caretaker for this particular juror.
Can you point to me, because I read the transcript and I didn't see anything indicating the judge had appointed the foreperson in the manner that you are arguing.
Well, if the juror was cleared and the judge made a determination that the juror no longer needed any assistance, then why is it that the foreperson sat in on the meeting with the juror about the juror's competency? That certainly violates Connors.
That's a different question than what you're arguing, I take it. That what you're arguing is somehow the foreperson was deputized by the judge to become some kind of medical caretaker for the juror. And I don't see that in the transcript. What I see, and it's true that the judge uses the word agent, but the judge clarifies immediately what the judge meant by the word agent there. So I'm hoping you'll just, let's look at, it always helps when we look at the actual page and see what was actually said in the record. So what pages are you,
I'm looking at,
you'd like us to look at?
Volume 11, pages 16 and 17.
Good, I'm right there.
Where the court initially says that
yep, she's kind of my agent in the jury room, yes. In the sense that I want her to let me know if there's anything that I ought to be aware of during deliberations. And that includes the well-being of jurors.
Yes.
So now why is not the foreperson actually the agent for sending notifications back and forth from the jury room to the judge?
Because this is more than notification. Once the judge allowed this juror, this foreperson, to sit in on a colloquy with another deliberating juror, the juror had information that the juror shouldn't have had if her sole focus was the foreperson. In other words, in this case, once the foreperson came in to the colloquies with the juror 13 who had the issues, that juror, the foreperson, now has personal medical information regarding this juror that foreperson had no right to know if we're going to have an equal and deliberating jury. And once that foreperson had that,
not objected to down below, and I'm trying to understand now if what you're arguing is somehow the judge, by using this procedure, the judge impermissibly disclosed, I guess, HIPAA type information to the foreperson.
No, not at all. He did, but that's not my argument. The issue here is that the need for the foreperson to know the personal medical status or psychiatric status of another deliberating juror is a problem. And when you say, how is this any different than a regular foreperson taking control of the jury, that's what makes it different. The fact that the judge thought it was important to bring in the foreperson when we're having a private colloquy with the juror is what makes this different than a regular duty for a foreperson. Because normally you would assume that the foreperson has no right to know what the problem with another juror is. In fact, under Connors, what the court said is that you're supposed to tell them, if you excuse them, that it has nothing to do with the case, it's personal to the juror. So if this was personal to the juror, and the foreperson isn't doing anything other than regular duties, I think that the presence of the foreperson in that colloquy is what separates it from the normal duties of the foreperson. And then on top of that,
hadn't maybe I misunderstood the record. hadn't the foreperson been part of conveying the information about this particular juror before?
No, what happened in this case is that the court officer took the note. The juror came in with the note. The court officer took the note. The court officer conveyed the note to the court. And at that point, there was some communication, I guess, in the jury room that morning between the foreperson and the juror. And this was the same foreperson that we all saw 2 days earlier when the juror broke down in the courtroom. It was the foreperson who was comforting that juror. And it was that issue in terms of bringing the foreperson in that showed that the foreperson was more than just the regular foreperson with this particular juror. And that creates a whole host of problems, because now it's our position that if this foreperson is an agent of the judge, which is what the judge told these two jurors, then what if they were on different sides? That unequal relationship now, where it appears that the foreperson has more power and is supported by the judge because the judge has picked this person to help this other juror, is a problem. In the basic problem behind that is that if the juror was cleared, if the judge could make this medical determination that the juror is cleared to serve on jury duty, then why did we need the foreperson at that colloquy? Why did we need to say the foreperson is my agent? Why did we need to do any of that if the juror was capable of serving on jury duty without any implications whatsoever?
Well, as I read the transcript, the judge appeared to be trying to convey to the juror that some reassurance that there was a mechanism for reporting any distress or difficulty she may have in the future by sending a note through the foreperson. That's the way I read the transcript.
I understand that that's certainly a possibility of reading the transcript that way.
And if that was what the judge was doing, if that's a reasonable reading of the transcript, then what is it that the judge did that was incorrect?
The judge allowed the foreperson to understand the issues with this juror, which never should have happened.
Okay, so as I said, is this some kind of HIPAA violation you're asking us to find?
No, it's not a HIPAA violation. It's giving the foreperson more information and more responsibilities and duties than the foreperson should have, which makes for an unequal footing within the jury room. What if, in this case, the foreperson was for guilty and this person was for not guilty? Now, this person has to go through the foreperson. The foreperson is taking care of this person. And there's an unequal deliberation in terms of everyone having an equal voice. This juror now knows that the judge has told this woman that she's in charge of what's going on with me. The judge has told this woman that she needs to notify the court if there's something going on with me. You add to that the issue that I raised at the end of the jury deliberations, when we do get that second note regarding a deadlock. When we talk to the foreperson about the deadlock, she says, I worded it that way intentionally. I intentionally worded it the way that I did. And I brought up the issue to the court saying, what if that's a signal from the foreperson saying, there's a problem. You told me to tell you, now I've told you there's a problem. And I asked the judge to inquire further, and the judge said no. Instead, he gave this instruction to the jury that he finds that no one has any problems with understanding the law, that no one is impaired in any way. And that's the end of it. So we don't know. When the foreperson said very specifically that she did that intentionally, I brought to the court's attention that this could be her way of telling us that there's a problem. And if there's a problem, we should address it. And instead of addressing it, the judge brought down the entire jury and said, I see no problem. Nothing's wrong here. Everybody's able to deliberate and just go on your, go and continue to deliberate. And it was literally 32 minutes later, after he made those statements, that the jury came back with a guilty verdict for the assault and battery dangerous weapon. And the problem in this case is that there was that non-specific, deputizing of the foreperson in this case. There was the sharing with the foreperson of the medical condition. And then there was the foreperson doing exactly what the judge told her to do, which is tell us if it's a problem. And when we ask her about it, she tells us it was specific. I did that on purpose. And I believed she did it so that she could not single out that juror again.
I have a question for you about the deputizing of the foreperson. At the end of the judge's main charge, he chose the foreperson, and he said, a foreperson is described as the first among equals. The foreperson is responsible for communicating with the court if necessary during deliberations. Are you arguing that that instruction was improper, or that because the issue that this juror had was a psychological issue, that the instructions shouldn't have gone through this foreperson?
No, I'm not arguing that at all. What I'm arguing is by creating this relationship with these two jurors, and it was judicially endorsed and created, places the judge's imprimatur on these two jurors. And I'm saying that's what's wrong here. You can't do that in a situation where every juror is supposed to have an equal voice. Because if one juror is in charge of another juror, then certainly the juror that's being cared for does not have an equal voice.
But he wasn't putting her in charge of her. So I would push back a little bit on that. But what if her issue was that because of some medical necessity, she frequently had to use the bathroom? And so the judge said, I'm going to tell the foreperson, without embarrassing her with all of the other jurors, that this may come up periodically. And so when it does, I'd ask that you take a break and excuse her. Would that have been improper?
In that case, I think it would have been. I think any information that you share with another juror that gives them information that they otherwise wouldn't have, that's what Connors says. It says if a juror is questioned, if a juror is excused, you can't then go on and you have to tell the juror it has nothing to do with their position on this case. It has nothing to do with their relationship with other jurors. It has nothing to do with the facts of this case. It's personal to this particular juror. And in this case, what we have is a situation that we know that sometimes jurors create alliances in the jury deliberation room. That's fine. But this is an alliance that we created. The judge created this relationship, and the judge created the subserviency of juror 13. But
okay. So if we don't, I'm trying to figure out where your argument hinges. If we do not share your reading, the meaning, your interpretation of the transcript and what happened, what then? What if we just read the transcript to be that the judge is trying to set up a mechanism whereby the juror knows that if she feels any distress, that the foreperson will send a note to the judge? What if we read it to be just that? There was no objection to that at the time. And what if we just read the transcript to mean that?
Well, Judge,
what happens to your argument?
Well, Judge, there was an objection because I wanted the juror excused. So
right, but there was no objection to this procedure, and in fact, you consented to it at one point.
And Judge, I also made it clear that we wanted the juror excused. So to say
I understand that, but I'm just asking you to go with my question for a minute.
If that's the set of facts, which I don't agree with, but if that's what it is, then you have to look at, I think it's volume 11, page 73. And I think it's volume 11, page 61, when this particular juror, after she was given that information, said, I did this on purpose. I sent this note on purpose, and then we don't inquire. So there's still a problem that should result in the reversal of Mr. Scott's conviction.
Well, could the judge infer from that the foreperson was intentionally making the number of jurors at issue plural, so that the judge wouldn't single out any one specific juror to add to the anonymity by making it a plural jurors instead of singular?
But I don't know what the judge's intention was, but when the juror, the foreperson, who's been explained to the judge to tell me if there's a problem, writes a note like that and says there's a problem. And then when we question her about it, says, I did it intentionally, and we don't question any further, there's the problem. So if you don't agree with my assessment of what happened initially, once the foreperson brings that to the juror's attention, it's another violation of Mr. Scott's rights. And I know I'm running out of time. If I could just quickly address the restraining order issue. The restraining order issue, Your Honor, is that in this case, there was a restraining order taken out by the family members of Mr. Scott 2 days before the funeral in this case. We thought it was important as to Mr. Guy Scott's state of mind, because he knew about the restraining order, to be able, I wasn't looking to introduce it as its truth for its truth, but just as to Scott's state of mind, why he would have had 3 guns in his car, why he would have pulled up beside the car when the car was next to the funeral procession. That went directly to his state of mind. And the other evidence that came in was either directed at other people or was in 2006. And I believe it would have made a big difference for the jury to know that 2 days before this incident, the alleged victim in this case threatened to kill his family, and he knew about it.
We understand your argument. We've got your brief. Your time has expired. Let me just check to see if there are any questions from the panel. No, thank you very much.
Thank you, Your Honor.
Attorney Nguyen.
Thank you. Good morning. May it please the court, Mary Nguyen on behalf of the Commonwealth. Unless Your Honors would like me to start somewhere specific, I just wanted to touch upon the standards of review with respect to the certain issues, because it didn't seem to be clear in the Commonwealth's brief, and I apologize for that. With respect to the argument with regard to the errors in the adjutant instruction, I submit to Your Honors that an argument can be made from the reading of the record that the objection was not specific as to defense of another. If you look to the transcript, and I'm pointing you to volume 7, page 107, it appears from my reading of the transcript that the objection was limited to adjutant instruction as it pertained to self-defense specifically. So my argument is that the objection was not specific as to defense of another, and therefore any error, if you find one, which I don't believe there was one, would be reviewed under a substantial risk of miscarriage of justice. Another clarification with respect to the standard of review would be on the issue of the defense of another instruction with regard to the judge's correct reading of the law with regard to the Commonwealth versus Allen case that defense counsel supplied to the judge. The Commonwealth's contention at this juncture is that the case law is clear in both Allen and the case that the Commonwealth cites in its brief, spelled MEIJA, which is 407 Mass 493, a 1990 case, that the standard of review on this particular issue with respect to a claim that somehow the instruction is deficient insofar as it misleads the jury with respect to burden of proof on defense of another, that standard of review, if there is in fact an error, which we're contending there is not, would be a prejudicial error. So that was also not made clear in the Commonwealth's brief. And then with respect to, there was just one final comment with respect to clarifying the standard of review on the issue pertaining to, I apologize. The restraining order issue. And I also can turn to the substance of that as well. But with respect to the appropriate standard of review, the Commonwealth suggests that the standard of review, if an error is found, is in fact prejudicial error, and that also was not made clear in the Commonwealth's brief. Having just clarified the standards of review for Your Honors, is there a particular issue that you'd like me to address at this juncture substantively? There not being I'm not seeing a question with respect to a specific issue, then I'll address the restraining order issue because it was raised by counsel. From the reading of the record, you can see that the judge made rulings with respect to the restraining order at sort of 3 different times as the trial progressed during the Commonwealth's case in chief. The first instance was with respect to the first witness, which was the defendant's mother. At that juncture, defense counsel represented that she wanted to admit the restraining order specifically to show that the defendant's sister was sufficiently afraid about what the victim had said. And
what about the fact that the judge at one point says, well, no one told me earlier that the defendant was aware that this restraining order had been sought? That's significant. I think your sister is arguing that that's a signal that if the judge had known about that, he might have let the evidence in.
Yes, and I do, and we do also discuss that in our brief as well. And just to comment on that, Justice Grant, by the time the judge was aware that the defendant's statements to the police included a statement that he was aware of the restraining order, the judge then appropriately permitted evidence to come in for the limited purpose of the defendant's state of mind and whether the defendant was acting reasonably in response to some apprehension of fear. So that evidence did come in, but in addition to that,
In what form did it come in? Was it in the videotape statement?
correct. And you'll see that
Do we have the videotape statement before us?
it doesn't appear that that was part of the record appendix from the defendant.
Why not?
There was a transcript, though, not the actual video, but
Is the transcript in evidence?
it is not in evidence.
So why is it in the record appendix?
I can certainly provide that after the hearing and expand the record if that would be allowed by your honors.
You should look at Mass Rule of Appellate Procedure 18, particularly 18B, and think about whether, when you filed your brief, whether you should have already provided us with every part of the record that we might need to rule.
I will certainly review that rule, Your Honor. If I could further comment on that point, I also want to just point out that the evidence was essentially cumulative when you look at the trial evidence that was in fact offered with respect to the restraining order. So that there was no prejudicial error given that it was cumulative on that subject matter. When we got to the testimony of the Boston detective, although his testimony was limited and only testifying that the sister had provided an order, essentially the detective on cross-examination was able to testify that the sister was upset and afraid that the family had an issue with the victim, that the victim had past history with the police, that he was known to the Boston Police Department, that he was a violent person, that he had a temper, and that that the detective knew the victim to be associated with a gang. You can find that in volume 2 on pages 284 to 287. And they additionally heard from the defendant's mother with regard to her fear of the victim and of her family's fear with respect to the victim. So the jury already heard all of this evidence. And in addition, they heard the evidence specific with respect to the defendant's knowledge of the restraining order so that they could assess the defendant's state of mind. So in that regard, even if you found error, which I don't believe there was, certainly it was not prejudicial. I'll turn to, unless there are any other questions on the restraining order issue, I can turn to the juror issue because that was also raised as well.
I could just touch on the restraining order thing just a little bit.
Sure.
Notwithstanding what the family members may have known, doesn't it rise to a little bit of a different level now that he's aware that there's a restraining order in effect and by the defense view is willing to violate it? Isn't that different than just family members being afraid of him?
Oops, sorry, I didn't hear the last part, Justice Desmond. Was there anything?
No, you heard the full
question. Okay. I apologize. So Justice Desmond, in response to your question, it was my reading of the record was it was pretty clear that there was no evidence to suggest, and none of the witnesses could offer any evidence that the victim was served with the restraining order, such that it was not effective in the sense that there was no indication that service was made to the victim. So we're not talking about a scenario where there was any evidence to suggest that the victim was aware of the restraining order and violated it.
What difference does that make vis-a-vis the defendant's state of mind?
So with respect to the defendant's state of mind, what's relevant is that he was aware of such a restraining order, and that evidence was put squarely before the jury when the judge did in fact learn that the defendant, there was evidence in fact offered vis-a-vis the defendant's recorded statement that he did acknowledge in fact being aware of the restraining order. So that evidence on this very particular issue was in fact squarely before the jury, and it was also argued by counsel during her closing argument. And if I may, at this juncture, then move on to the juror issue, if there's no other questions on the restraining order issue. The Commonwealth submits that the judge handled the situation as she should have, and the Commonwealth requests that this court give deference to the judge's judgment. The record is before you, and you can, in a careful reading of the record, will suggest to your honor that the judge was very careful into handling this very delicate issue. He took time to hear from both counsels. He also read relevant case law.
Why does it make sense to have the jury foreman present during the inquiry of the juror who had the medical problem the night before?
So at that juncture, my reading of the record, I think, is similar to yours, whereas I also read it as there was some indication on the record that the judge was made aware that the forewoman, the forelady, was also apprised of the situation with respect to this particular juror number 13.
But even if that's the case, why have the foreperson present during the judge's inquiry of the juror about how she feels medically and about her willingness to continue to serve and her ability to continue to serve?
So my sense and my reading of the record with respect to that particular occurrence was, my reading of it is that at that juncture, the judge wanted to ensure that there was a proper channel of communication between juror number 13 and the judge with respect to accommodations with regard to her any potential stress down the road. We've already addressed the fact that she was medically cleared as per that note that the judge referenced. So my reading of the judge's action in that regard was for accommodation purposes with respect to communication, which is appropriately done through the foreperson.
Wouldn't that have been better done? Wouldn't it have been better to have the foreperson introduced into the mix after the judge made the initial inquiry of the juror alone about the medical circumstances and her current frame of mind and situation?
I don't know necessarily if it would have been more appropriate. I think that.
Why don't you, what if we hypothetically assumed that at the end of the inquiry, the judge concluded that this juror should be excused? In that case, then the foreperson would have returned to the jury room knowing the circumstances of why that juror had been excused. Is that proper?
So it's difficult because if I'm not mistaken, in your hypothetical, are we assuming that the issue would be personal to the juror? Because in this instance, we're contesting that. We're suggesting that the issue was not personal to the juror, that the issue was with respect to intertwined with her difficulties with deliberation, which is not a good cause to excuse the juror. So is your hypothetical sort of premised on the proposition that perhaps it is a personal issue?
Maybe I'm misreading the record, but this juror had an anxiety attack one day in court and was in the hospital the night before this in-camera discussion occurred. Am I wrong about that?
So, well, the Commonwealth
why is that not personal to this juror?
The Commonwealth has a different reading of the occurrence from our reading of what had occurred, and from the record, it would all the responses from the juror and also the note would indicate that her level of anxiety was specific to deliberations. For example, she made a joke.
By that, do you mean that it was caused by her experience as a juror? Is that what you're saying?
It was due to what was going on in the deliberation room. Yes.
But that's not what did the note ask that? I thought the note said that, I don't think they used the word deadlock. I think they used the word impasse, but nevertheless, as a result of, we're not sure that the juror answered the questions adequately to be able to understand the concepts, and I'm paraphrasing a little bit.
So, Justice Desmond, that's another note, and there's no indication. So that's the note where the four lady indicated jurors, plural. So there's no indication that that is the specific juror. I know that counsel has a belief that it is, but there's no indication in the record that it is in fact the same juror. I'm
having a hard time understanding what you mean by it's not specific to this juror. It seems to me what you're arguing is that because the cause of her distress was part of the process of being a juror, it therefore is not specific to her.
Oh, no, I apologize. I was arguing two different points. Justice Desmond had raised a note, a different note, not with regard.
I understand that. I'm going back to my question.
Okay. So I'm sorry, can you give me your question? And again, I apologize.
Sure. My first question was my hypothetical about why is it appropriate for the foreperson to be present during the inquiry into this juror's current well-being and state of mind and fitness to serve on the jury. And you said because the problem with this juror was not specific to her. And I'm having a hard time understanding that answer.
So, so just going back on that. So I had asked the question if your hypothetical was assuming that it was a personal issue, and then you heard my responses with respect to our reading of the record that it's not personal. When you look at all the cases that have been cited in both parties' briefs with respect to this issue, you can see in every case, including Swafford, I believe, that the foreperson has played a specific role in each one of these juror issues with respect to every so-called problem juror, if you will. So there was even one instance in one case where the judge didn't want to hear from the specific juror. He wanted to actually receive the communication first from the foreperson. So in all of those instances, just as in our case, the foreperson was in all intents and purposes apprised of the situation and asked to be the person to communicate anything with respect to that specific juror. So I don't think there was any impropriety necessarily by including the foreperson. And I think Justice Grant, you had a question.
Justice Grant.
Back to Justice Wolohojian's question about whether or not it's specific to the juror. My understanding is the judge is not supposed to inquire about the content of the deliberations. And it sounds to me like what you're arguing is that the judge could infer that the reason for the juror's distress had to do with the content of the deliberations. And if that's the case, where are you getting that?
No, not the content of the deliberations, just stress as a result of deliberating. She had indicated that in her responses during the voir dire, during her individual voir dire. I hope that answers your question.
Let me look and see if there are any other questions. If not, we'll have to leave it there. All right, thank you both. It's an interesting case. We've been helped by your argument, and with that, the case is submitted.
Thank you.
Thank you, Your Honor.
Oh, Attorney Petito, you may want to put yourself on mute. Oh no, sorry, Attorney Nadeau, you may want to put yourself on mute.
Yes.
All right, we're live and recording.
Good morning. Welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this fashion due to the ongoing pandemic. My name is Gabrielle Wolohojian, and this morning I have the great pleasure to be sitting with Justices Desmond and Grant. Although we're sitting in this format, all the ordinary rules of argument before our court apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus Ryan Gamboya, 2019 P 0708. And Attorney Petito, we're ready whenever you are. You're on mute.
Good morning. May it please the court. Joanne Petito for the defendant, Ryan Gamboa, in this case. The instruction on assault with a dangerous weapon in this case was deficient. It was deficient because it did not include the requirement that the defendant come reasonably close to accomplishing the intended battery. The judge gave the Superior Court instruction as requested by the parties in this case. However, at that time, the Superior Court instruction did not include the required language that the defendant come reasonably close to accomplishing the battery. That instruction was changed subsequent to this court's decision in Commonwealth versus Budasing, in which this issue was addressed. The instruction now does include that language. The change was made to make it essentially consistent with the district court instruction, which did include that language. Because the instruction that was given did not include the requirement of coming reasonably close to accomplishing the battery, there is a substantial risk of a miscarriage of justice that the defendant was convicted upon less than proof beyond a reasonable doubt of every fact necessary to convict.
I asked you about, now I understand that in Budasing, we determined that this this model instruction was not correct, although in that case we also concluded that there was no substantial risk of miscarriage of justice posed. I'd like you to, was the entire instruction the same in this case as in Budasing?
I don't recall specifically. I don't know whether the specific language of the instruction as given was indicated in Budasing. And I don't recall, but I know that the problem in Budasing, as I understand it, was that reasonably close language.
Right. So the reason why I asked this question is because, and I'm having trouble pulling it up on my screen here, but maybe you can help me. Which page is I'm in trial volume 8, I guess. And I'm looking
in the brief
at, no, I'm looking at the transcript of the instruction. And I'm looking at the language on page
908 to 909.
Right, exactly. And I'm on 909 right now. So okay. I'm looking at the first 2 full paragraphs on that page. And in particular, the first one of those, that the Commonwealth must also prove that the defendant did an act towards the commission of inflicting physical harm on the victim. In other words, the Commonwealth must show that the defendant did, in fact, attempt to do bodily harm to the victim. And do you know whether that language was given in the instruction in Budasing?
I don't recall. I don't recall.
So then my second question then flows from that. Oh, well, and also then it goes on in the next paragraph. The Commonwealth must prove that the defendant had the actual or apparent ability to inflict bodily harm. So, and if we, my second question is, why does the language I read not come, and I hate to say this, but close enough to the close to language, if you see what I mean?
Yes, it's because coming reasonably close is an additional requirement which is in addition to committing an act. An act may be committed, which is part of attempt, but the language of the instruction was changed, and generally a change indicates something different.
Sure, but I'm not quarreling with the fact that it didn't include the close to language. But what I'm thinking about is the line of cases that says that we read the instructions as a whole to determine whether the concept was conveyed to the jury. And this language that says that he did an act towards the commission of inflicting physical harm, and that the Commonwealth must show that the defendant did in fact attempt to do bodily harm. The attempt to do bodily harm seems pretty close to me to the close to language.
You can have, my understanding would be that an act, you can attempt to commit a battery through an act that if the language reasonably close is not there, it can be an act that does not come reasonably close to accomplishing the battery.
But if he did in fact attempt to do bodily harm, you don't think that a juror would reasonably understand that to mean that the act isn't that remote, but that it's an act to, because it's the language that says in fact to do bodily harm.
I think that reasonably close is part of a definition of attempt in this instance. Attempt is fairly general, and the language reasonably close is an additional requirement. For instance, in this case, an attempt could be seen as committing the act of, say, brandishing a knife, which the defendant admitted in this case. That is part of an attempt. If there is actually an attempt to inflict harm on someone with a knife, brandishing, taking the knife out, is an act towards that end, and it is part of attempt.
It's not an attempt. Would you say brandishing is an attempt to do bodily harm?
It's an act.
That seems different than what the instruction here says to me.
I think that without the reasonably close language, there could be some confusion as to that.
Let me ask you a hypothetical question. If somebody pulls out a gun and aims it at somebody, and right when they pull the trigger, someone else grabs their hand so that it ends up that they shoot the gun, but the bullet goes far away from the intended victim. Is that an attempt, even though the bullet didn't come reasonably close to the victim?
Well, in that case, the defendant's actions came reasonably close to committing the act. It was someone else who interfered and avoided the act. But the defendant's actions in that hypothetical of pointing and pulling the trigger is reasonably close. It was interference by a third person that avoided the act. But if the defendant in that hypothetical simply points a gun at somebody, there would be a question as to whether it came reasonably close.
So reasonably close isn't just a matter of geographical proximity. It's a matter of the actions that the defendant has set in motion.
Well, I think it could be, I think it could be both. And I think, in fact, part of the facts in Budusing was that the defendant in that case, who was wielding a weapon, came at someone, and there was language in the decision that they were close to each other, rushing at somebody in close proximity, and then someone else came in and stopped the weapon from striking the individual. So being close can be a part of that. Swinging, for instance, swinging a bat at somebody who is 20 feet away is not reasonably close, but swinging a bat at somebody who is 2 feet from you could be reasonably close. What
was the evidence as to how far apart the victim and the defendant were when the defendant pulled the knife out?
There is no evidence as to how close they were.
But the
video didn't show us. The video showed mostly was from inside the store, and I don't think that the other individual, Barbosa, could be seen from the video. And the testimony did not include any facts about how close they were. There was testimony from one person who said, I think I saw a swing, but there wasn't any facts as to how close they were.
Well, but if I understand your response to Justice Grant's question, physical proximity, in your view, is important in answering the question of whether it was close to accomplishing the crime. And so if that's the case, I'm having a hard time understanding why, in your view, taking the swing with the knife would be sufficient here to become close to, but brandishing the knife wouldn't, if we assume that the actors were at the same distance from each other in both cases.
I'm not necessarily assuming that swinging the knife would constitute a battery. What I'm saying is that that could be a factor. And what I'm really getting at is part of the determination of whether it causes a substantial risk of a miscarriage of justice is whether the evidence in the case would have compelled the jury to find that the defendant came reasonably close, satisfy the missing element. And here, because there was no evidence of how close they were, even if the jury had accepted the swing, it still doesn't compel a finding that it was reasonably close, particularly because there was also testimony that Barbosa was running away and the defendant stopped.
How do you know that the surveillance video doesn't show how close they were? Isn't that in the record?
I'm sorry, I missed the first part of what you said.
Isn't the surveillance video in the record? And why isn't it before us? Wouldn't that tell us whether or not they were close?
The record does not, from my recall of the record, and maybe the Commonwealth has a different memory or found this someplace else, I do not recall any evidence as to how far apart they were. I can certainly ask to have that exhibit transferred to the court. I've viewed the videotape. I do not have a version that is marked as Exhibit 3, which is what it was. So I would like to get that particular version transferred to the court. The Commonwealth may have that exhibit.
It would be most helpful if the two of you could work together to get the actual trial exhibit conveyed to us. You may need, my understanding is sometimes if you have trouble, sometimes an order from our court will help so you can communicate with the clerk's office. I had another question about just essentially the record down below, which is this argument depends in part on your identifying that the two possible factual bases for conviction would be the brandishing of the knife or the swing. And I looked to see what the jury were told or how the parties argued what was the act underlying the ABDW charge. And I couldn't see anyone saying it was this or that. You know, the indictment just says that it was with a knife and nothing more.
I recall that I know that the defendant argued that there was no swinging. So, and it was just a brandishing, and there was no indication of how far apart they were from what I recall. The Commonwealth did not argue to the jury what the particular act was. Am I correct about that? I don't recall whether they did. I don't recall that. I don't recall whether
I didn't see it in the closing, and the judge certainly did not give any guidance in the instructions to the jury as to which particular act it was. And you know, one of the questions I had is why isn't following the victim out of the store towards a line of anticipated gunshot fire while brandishing a knife, why isn't that enough?
Well,
to
the jury,
form the basis of the ABDW charge.
the jury acquitted on the murder charge, which relied on the joint venture, which is what could have suggested an anticipated gunshot, and the jury did not accept that. So the jury appears not to have accepted that.
Well, but he follows this victim out of the store while displaying a knife. There appears to be no dispute about that.
That's correct.
Why isn't that enough to satisfy the elements of assault and battery with a dangerous weapon?
Well, because brandishing could be simply a threat or an attempt to ward off, which is what the defendant argued, that the defendant was simply trying to ward off Barbosa and was not attempting to assault him. And again, as for the fact that the individual was shot seemingly from an individual standing on the corner, the jury did not accept that that was arranged and anticipated. In fact, the individual who supposedly shot the person made a statement that that shooting was not arranged, it was a spur of the moment. So the jury did not seem to accept that it was arranged and anticipated that this person would be shot.
Okay, we'll have to leave it there given that your time has expired, but let me see if there are any further questions. No, thank you very much for your argument.
Thank you.
Attorney Nadeau.
Thank you, Your Honor. I think Justice Dedman's microphone was on mute. I don't know if he had a last question at the end there.
I was going to ask just one other question. Can't we infer, Attorney Petito, that they were reasonably close? I mean, the argument was, as I understand the facts anyhow, is as the defendant was coming out of the store, he was punched in the face by the victim. So we know they were close enough to touch at that point. And that's when he brandished a knife. And I think there was evidence that he swiped at the defendant. Doesn't contextually, doesn't that tell us that they were reasonably close to one another?
Well, I'm sorry, I think part of that was muted at the very end.
No, that's just the time lag.
Oh, okay. Well, having the video sent might might clarify it a little bit. After the punch, the defendant stumbled backwards. So there were a few seconds before stumbling backwards and then pulling out a knife, which is held at his side, and looking, and then going through the doorway. And during that time, all that time, there is no swing. And there was testimony that Barbosa was running away and that there was swinging. So there was a hesitancy, the individual was running away, and we don't know how close they were, if this swing, how close they ever got, and when, at what point in time this swing occurred. There was only one individual who testified to, I think, seeing a swing, and there wasn't any testimony as to where they were at the time.
And the argument to the jury was that he was trying to ward him off while the victim was running away.
Yes. Yes.
Okay, thank you.
And then he stopped and turned back.
Attorney Nadeau.
Thank you, Your Honor. Good morning. May it please the court. I'm Stephen Nadeau on behalf of the Commonwealth. To answer one of the questions Justice Wojciech sort of ended on regarding which act constituted the assault, just preliminarily, I did not understand any of the defendant's arguments on appeal as challenging the sufficiency of the assault conviction itself. But I don't think the prosecutor spent much time in closing on delineating which conduct, brandishing or slashing, constituted. Again, this case was...
He didn't spend any time. There was absolutely no explanation of which act the Commonwealth was relying on.
Well, I as I understood it, this was not necessarily a case of conflicting accounts of the assault, but just certainly at least 3 witnesses who saw different parts of the same continuous conduct. Not all of them saw every piece. That I think DeAndrade was the 7-Eleven employee who offered the most complete testimony. And he did describe seeing an actual slashing motion that did not connect with a knife in the hand. One of the individuals, I think it was Mr. Alves, outside the store, also saw the knife in the hand. And then, of course, when Mr. Barboza turned tail and fled, the defendant continued to pursue, still brandishing that knife. But I think the assault and pursuit is all part of the conduct that would be the assault with a dangerous weapon, not merely taking the knife out and holding it. And I don't think that's what the record here shows. But again, I don't understand. I don't think sufficiency is raised here.
No, I think it's not about sufficiency. It's about the interpretation of the facts, as I understand it, as it might bear in the substantial risk analysis.
Sure. And well, in that case, again, I don't see this as 2 conflicting theories. This is just different observations of a continuous course of conduct. Turning then to the issue that counsel began with in her argument, I would analogize the new instructions or the updated Superior Court model instructions on assault with a dangerous weapon, similar to the updated instructions on the Webster charge for not proof of guilt beyond a reasonable doubt. What is reasonable doubt? Where the courts have now modernized some of the language, streamlined it so it's easier for a modern lay jury to understand. But I think the old sort of more intricately worded Superior Court model instruction conveys the same essential elements. In Commonwealth versus Poro, in footnote 5, the court kind of defined that reasonably close language as simply meaning that the defendant committed an overt act or acts that brought him very near in time and ability to the actual commission of the completed crime, in this case, the battery with a dangerous weapon. But the then current Superior Court model instructions required proof of an intent to physically harm the victim and act towards the commission of inflicting that harm while having the actual or apparent ability to inflict it. So again, if he's slashing from opposite sides of the store, parking lot, just slashing at the air, he doesn't have the apparent ability to inflict the battery at that time. And as the court explains in Poro, he's not near in time or ability to the actual commission of the completed crime. He does not come reasonably close to completing a battery. But looked at as regarded as a whole, the old model instructions necessarily require proof of an assault that comes reasonably close to being a completed battery.
Well, what do you do with the fact that what are we to do with the fact that in Buddha Singh, well, let's start somewhere else. I'll ask the same question I asked your sister, which is, in your view, is the instruction that was at issue in Buddha Singh the same as the instruction that was given in this case?
My reading of the one in Buddha Singh is that it seemed to be the same. I think the essential elements that are relevant to the court here are the same that were present in Buddha Singh. But my reading of the Buddha Singh decision is that the court sort of acknowledged that the district court language of this reasonably close was maybe preferable, more clearly in clearer language states the elements, but Buddha Singh did not resolve the adequacy of the instruction itself. So I guess because there was the other theory of assault with a dangerous weapon that the Commonwealth proceeded on that we did not proceed on in trial here. So I think now the adequacy of the instruction is right for the court, and that while the new language is preferable, the old instruction is indeed adequate to convey all the essential elements of assault with a dangerous weapon under the attempted battery theory.
In our substantial risk of a miscarriage of justice analysis, Does it matter that Buddha Singh had been decided more than 2 years before this jury was instructed, and also that the Superior Court Model Jury Instructions are a book published by MCLE as opposed to something promulgated by a court?
Well, so the model instructions would not be binding, but obviously would have been used through many cases that this court and the SJC has passed on over the years by its nature. But the instructions themselves published by the ACLU are not an authoritative source, obviously. I'm sorry, your question.
Buddha Singh was 2 years before. Shouldn't that have been something that the Commonwealth should have found out about before the charge conference?
Well, arguably, any of the parties, both parties and the court sort of agreed on that this was to be the instruction. But where Buddha Singh doesn't resolve the question, it might have been preferable that we had used the new language, but there was no clear law at the time saying that we should not have, or that this language was in fact inadequate. And again, I believe it was adequate, although again, in more convoluted, perhaps language, but there's no evidence that the jury here would have been confused or any view of the facts. Again, as Justice Sesman noted, there was some evidence of a sucker punch straight to the face. So these guys are in close quarters. Any slashing with a knife that the defendant makes in those quarters is going to be an act that comes reasonably close to completing the battery. If there are no questions on that particular issue, I would just address briefly the other issues in case the court has any questions. The defendant raised the failure of the trial judge to instruct on self-defense. No view of the evidence here supports a self-defense instruction because there's simply no evidence that the defendant availed himself of any attempt or made any attempt rather to retreat or any indication that he could not have retreated further into the store or behind some obstacle or to the assistance of the clerks before he immediately reached into his pocket and slashed with the knife. There's no dispute. Certainly the Commonwealth did not dispute that the sucker punch came first. The indication is that the defendant was responding to that punch. Nonetheless, he has a duty to at least attempt to retreat, and the record is devoid of any evidence supporting that. Turning then to the admission of the cell phone records, again, I'll address sort of our main argument, which is the harmlessness, even if the court reaches some of the statutory or warrant-related issues and resolves those against the Commonwealth. The admission here of the record was harmless. As with much of the evidence in this case, it was admitted to show that the defendant was guilty as a joint venturer in the later shooting, not stabbing or not related to the assault of Julio Barboza and, excuse me. And that phone evidence did not bear at all on the assault that happened immediately after the sucker punch, where the defendant did not retreat and nonetheless slashed at the victim and then chased him out of the store. So where the challenged evidence did not bear on any live issue underlying the conviction, I would suggest that its admission, even if error, was harmless. If there are no further questions from the panel, I would simply rest on the arguments in the brief.
Let me check. I don't see any. Thank you very much, Attorney Nato. Thank you very much, Attorney Petito. It's an interesting case. We've been helped by your argument, and the case is now submitted. Is that incorrectly? You are arguing first, and so Attorney Hoffman, I recommend that you mute yourself.
Will do. Thank you.
Thank you, Your Honors. May it please this court. My name is Ilir Kavaya, and I, along with Attorney Paul Nevins, who's present with me today, represent the appellant Michael Alfieri. Your Honors, the purpose of the Wage Act is to protect employees and their right to wages. That has been repeated by the SJC throughout its jurisprudence and also in Parker versus Enernock. The Wage Act the Wage Act is a comprehensive remedial scheme that regulates the payment of wages, and it is intended to provide strong protections for workers. That's from Crocker versus Townsend Oil, 464 Mass 1 at page 12. The Act specifically forbids special contracts between an employer and an employee that purport to exempt the employer from the requirements of the Act. The special contract provision generally prohibits an employer from deducting or withholding payment of any earned wages and cannot be overcome by an employee's assent, both because the Act itself makes the special contract prohibition unconditional and also because of reasons of public policy.
Counsel, I have a question.
Yes, Your Honor.
As of the time your client left Merrimack in January of 2017, what had he done to earn the retention amount?
He had worked the entirety of the preceding year, 2016. There was nothing else that was required of his doing in order to earn that amount. There was a wage under the Wage Act. Any provision of the offer letter containing clauses that purported to withhold payment of that annualized total compensation to him is in fact, or was in fact, a special contract under the Wage Act. And I believe it was Camara versus Attorney General, where the Attorney General argued the proposition that I just stated, that based on just the Act itself and based on principles of public policy, just because an employee agrees to an offer letter or to an employment contract doesn't mean that the employer can get away from its obligation, can escape its obligation under the Act. The SJC specifically stated that the Attorney General's reading of the Act was reasonable and adopted that holding, Your Honors.
So here we're not talking about a commission, and arguably not talking about salary. I think your brother would say that it was a bonus, and you're not saying that it's improper to have a bonus structure that pays later in time, are you?
Certainly not, Your Honor. A bonus is a completely discretionary payment. We're not disputing that. Weems versus Citigroup makes that clear, and its progeny. However, this wasn't a bonus. This was anything but a bonus. And we know this in a number of different ways that it wasn't a bonus. Number one, when Merrimack Pharmaceuticals intended for something to be a bonus, they specifically had a different clause in their employment agreements that called it either a discretionary bonus or a bonus. We have submitted 10 such employment offers or employment agreements from Merrimack to its employees and executives. Further stating, Your Honors, Merrimack admitted that this was earned compensation to a contemporary of Mr. Alfieri, Klaus Becker. We submitted emails between Merrimack and Klaus Becker where Klaus Becker states, "This is my earned compensation. When are you going to pay?" Merrimack didn't deny that statement, that it was an earned compensation from the previous year. And therefore it is an admission by silence, because a regular person or entity in this case, in the shoes of Merrimack, would have written back and said, no, this is not earned compensation. But they didn't do that. Let's not lose sight of the fact that we are at a Rule 56 hearing. And while the jury could certainly choose not to believe that that's an admission, it would be an admissible piece of evidence that then the jury could weigh and accord a due weight.
Did Mr. Alfieri believe that it was a bonus? Doesn't he characterize it as such in a communication with another future employer?
No, Your Honor. So there is a distinction to be made. Mr. Alfieri, in October of 2016, was told, and this is contained in his affidavit that was submitted in support of our opposition to summary judgment. He was told that, hey, the company is going to be sold. You're going to end up without a job. There's a potential. But if you stay, when the sale happens, we will pay you a retention bonus. So that bonus he was giving up by leaving, and he knew that. That was entirely separate from the retained portion of his total annualized compensation. And again, it's total annualized compensation. That's what his offer letter says. I'm sorry.
How do we look I have a couple questions for you.
Of course.
How do we look beyond the language of the offer letter, which at least in your position is a contract? How do we look beyond the language of that unless it's ambiguous? Is your argument that the language of this letter is ambiguous?
The argument, Your Honor, is twofold. Number one, it is that a contract doesn't preempt the wage law. And to the extent that the contract contains special provisions that are aimed at depriving an employee of wages, those are unenforceable. And there is electrical.
So, I mean, stick with me if you would.
Yes.
Okay. I'm looking at page 201 of the appendix, which is the offer letter.
May I just have
Because I don't think we're going to get anywhere unless we stick first with the actual language of the agreement.
Yes, Your Honor.
In my view, it's not usually so useful to characterize these things, but rather to look at what's actually said.
Yes, Your Honor.
So, you know, first of all, there's this thing that's called total target cash compensation. And I take it that we would need to give some meaning to the word target. The second thing is that in the second sentence of this paragraph, it says a percentage of the total target cash compensation for each employee is retained and expected to be paid. And I assume we would have to give some meaning to expected in the first quarter of the following year. And then it says presuming that, and I assume that we would need to give meaning to the words presuming that. And then there are 3 conditions. What is your closest case looking at language like this, saying that whatever this type of compensation is, it is a wage within the meaning of the Wage Act? And here I'm looking for a case name.
Yes. The case name is Electrical Data Systems versus, I believe, the Attorney General. The site is 454 Mass 63, and it's at pages 65 through 67. And it says, I quote from the case, the Wage Act is, quote, meant to protect employees from the dictates.
I'm not looking for that kind of language, with all due respect. I'm looking for what was the language in that case of the contract.
I frankly don't know the language of the contract in that particular case.
Right. So what I'm looking for is in which case what is the closest case where we looked at a compensation structure such as here, and a court said that compensation structure was wages for purposes of the Wage Act?
Well, in one of these conditions here, and I do want to point out that the title of that clause says total cash compensation. The word target is in the body. I also do want to point out that it says that this portion is retained. And again, the appellate court, this court and the SJC has consistently held that we can look at the dictionary to mean to understand what that means. Someone or an entity cannot retain something that already belongs to them. That makes no sense. Why would they need to retain it if it belongs to them?
All right, but the word after that also is and, which we always construe as being conjunctive.
Yes, Your Honor, it is.
Okay.
So Parker versus Enternon, the SJC says you cannot have a requirement of being present in the workplace in order to pay that wage. Especially when the employer creates the contingency, the situation where the employee isn't there anymore. And this is akin to that case because Mr. Alfieri is told 2 months before he resigns that the company is going to be sold and you're likely going to end up without a job. So what's he to do? Roll his dice and wait? No.
But those are different arguments. We're just trying to focus on whether this compensation system constitutes wages for the Wage Act. Not that, that's all we're trying to figure out, or at least that's all I'm trying to figure out, because you're arguing that there was a violation of the Wage Act.
Yes. So in Enternock, Parker versus Enternock, the SJC in note 11 particularly states that although the act doesn't define wages, the SJC states, the plain and ordinary meaning of the word wage is defined as a pledge or payment, usually monetary remuneration by an employer specifically for labor services. And this is exactly what it is here. Is Mr. Alfieri is getting compensated to work there, to perform his work.
Are you aware of the line of cases that say in order to constitute wages, the particular form of compensation can't be contingent unless it's a commission?
Well, Your Honor, yes, I am. However, this isn't the case here. This isn't the case here because a contingent compensation, generally, the only recognized form of contingent compensation are commissions. So this isn't a contingent compensation situation. It's either a bonus or it's a wage, because the SJC has stated repeatedly that the only contingent compensation is a commission. So we know this isn't a commission. Okay, so that we're not arguing this is a commission. We're saying this is.
The SJC says the only type of contingent compensation that falls within the Wage Act are commissions. And
Right.
you agree this is not a commission.
We agree that this is not
Okay.
a commission.
So now if let's just say I read this language to be contingent on the satisfaction of 3 conditions.
So if you were to read it,
Then what happens to your argument?
well, the argument still stands, Your Honor, because if you look at the 3 conditions, and let's just get this out of the way. One of the 3 conditions is that Mr. Alfieri perform his work satisfactorily. That is not a disputed fact in this case. The other condition is that the company must be doing well as determined by the board of directors in their discretion. That is a completely illusory term, and defendants and appellees in this case conceded that during oral arguments in Rule 56, that sure, they have discretion, whatever they want. Well, you can't have that type of contingency if it doesn't give notice to the person that it purports to control. How is this? There has to be some sort of objective measures.
That's a normal condition for the payment of a bonus.
Yes, but this isn't a bonus, Your Honor. Again,
Let's maybe get away from labels. I don't know how we would know a bonus other than by recognizing it as something that's dependent upon some discretionary judgment by the controllers of the corporation. And then there's also the first condition, which is that the employee is an active employee of the company on the date that their retention is paid. And I take it it's undisputed that the plaintiff was not an active employee on that date.
well, so the offer letter says they would pay it in the first quarter of the following year.
It says it's expected to be paid.
In 2017, it wasn't paid until the second quarter of that year.
It got paid in April after the company sold a portion of it, but nevertheless, he wasn't working there in April, was he?
No, he was working there in January. As of January 7th, he resigned and he left.
But doesn't it say at the time of payment?
It does, but again, it says in the first quarter, and the first quarter of the following year, if this is a wage, that's an illegal detention of the wage because it's 90 days when it's supposed to be paid at the next regular scheduled payroll.
What are we to do with the word expected?
Again, Your Honor, this is a letter or a contract that is drafted by the employer. And in 2 separate occasions, the SJC has held that an employer cannot shrewdly draft an instrument whereby it escapes its obligation to pay wages. It cannot exempt itself by these special provisions that it drafts and call it something else when in fact it should be a wage. Mr. Alfieri performed all the work. There was nothing else for him to do. This was a wage, Your Honors. And
your brother points to the unpublished decision. I think it's Young. What do you say in response to that?
Well, Your Honor, an unpublished decision is just that it holds some persuasive value if it's subsequent to 2015, but it's certainly not binding on this court. And there's a plethora of case law from this very court and from the SJC that are binding decisions that hold to the contrary. So
you're referring to Parker and Calypso? One dealt with a commission.
Parker versus Enernock, right? Is that the case, Your Honor?
That's one, and then the other case I thought you cited was Calixto, or?
Yes. Again, to the extent that this case would be akin to commissions, is that we know what the amount that was held back was, and we know that all the work had been performed to be paid. But again, this wasn't a sale situation where he earned a commission. So, Your Honors, I noticed that my time has expired. In closing, I would like to reiterate that this was a wage that, and the special provisions in the contract are prohibited by the SJC. To the extent that this court holds that it wasn't a wage, I would argue that the three conditions, two of them are too vague and ambiguous and thus illusory to be enforced. Unless the court has any questions, I would rest on the brief, Your Honors.
No, I don't see any. Thank you for your argument.
Thank you, Your Honor.
Attorney Hoffman.
Thank you very much and good morning. I'm going to start out by saying I certainly agree, and you can tell from my briefing that the focus should be on the wording of the offer letter. Before I forget, I do want to respond to Justice Desmond's question about an email comment that the plaintiff had made in an email, labeling it a bonus. I'm looking at that email and it's page 180 of the appendix. It's at the bottom of that page. And here, Mr. Alfieri is referring to the retention payment from his original, the retention bonus from his original offer letter. And what he says here is, I'll be walking away from a $55,000 retention payment, and then in parentheses, it says guaranteed bonus. So he's not talking about the separate retention bonus agreement that he signed. That was for $43,000. Here he is calling his own $55,000 retention a bonus. And it was also labeled a bonus in his pay stubs. But again, going back to the language of the offer letter, it clearly distinguishes between his guaranteed salary on one hand and the second independent piece of compensation, which is what we're calling the retention. And it clearly, I don't know how you could possibly read this letter to say that that wage or that amount of money, the retention, is earned unless the three conditions are met. And even under the Wage Act, to see if wages are earned, you need to look at the arrangement between the parties. He was paid all of his guaranteed salary. He did not earn this extra bonus because he didn't fulfill the conditions. He left for a higher paying job in December of 2016, effective January 6th of 2017. And that was certainly his right to do. I don't blame him for taking a higher paying job, but he can't have it both ways. He can't do that and then also claim he's entitled to collect this extra money, this bonus, which he would have only been entitled to if he had remained at the company through the time it was paid. The offer letter, by the way, said it supersedes any prior understandings. It also says nothing in the letter should be construed as an agreement to pay any compensation after your employment ends. And there's certainly nothing unlawful about a retention bonus or any other sort of contingent bonus that an employer might want to offer on top of his salary.
Attorney Hoffman, you say that this pay structure is widely accepted in Massachusetts, but the best case you had was an unpublished one. Do you have another case?
There are other cases that talk about retention bonuses, and I can certainly find them.
Well, what was your best case?
Well, there are, one that comes to mind is MUI, which, as you said before, talks about contingent compensation, and the only kind of contingent compensation that falls within the Wage Act is a commission, and we have an admission that this is not a commission. Now, reading a clear and unambiguous contract is certainly a matter of law for the court to decide, and plaintiff, for the most part, agrees that the offer letter is not ambiguous. He just has a different reading of it, but his reading focuses on two specific terms instead of looking at the full context of the offer letter, particularly the part that discusses his compensation. And he also concedes that all of his extrinsic evidence is only relevant if the offer letter is ambiguous. It's clearly not ambiguous. That's the plaintiff's primary argument, is that it's clear. I could run through those pieces of extrinsic evidence if you'd like, but I think we covered them all in our brief. The only one we didn't cover is the emails that counsel just mentioned with a gentleman named Klaus Becker. Those weren't covered in the plaintiff's brief. If he wanted to make that part of his argument, he should have covered it in his opening brief. So I can talk about it if you'd like, but I believe he's waived that argument.
I think we understand your argument. Let me see if there are any questions for you. I don't see any. Is there anything else you'd like to add?
No, unless you have questions for me, I think I've said what I need to say.
No. All right. We appreciate both of your arguments. They've been very helpful to us. And with that, the case is submitted. Paul Breen versus Massachusetts Port Authority, case number 2020P0199. Attorney Houston, we're ready whenever you are. And Attorney Hambleton, I recommend you put yourself on mute. Thank you.
Thank you. Members of the panel, may it please the court. My name is Todd Houston. I represent the self-insurer in this case, the Massachusetts Port Authority, the appellant in connection with this matter. This is the self-insurer's appeal seeking redress in connection with a workers' compensation hearing decision authored by an administrative judge at the Department of Industrial Accidents. It is our position that this hearing decision is fatally flawed and inconsistent with the statute and this honorable court's rulings and dicta. Massport is seeking relief in this particular case, requesting that the court reverse the decision of the administrative judge and the reviewing board who summarily and incorrectly affirmed the hearing decision.
What is our standard of review?
You are entitled to review any indication that the decision is arbitrary, capricious, or contrary to law. This is a factual case based completely upon the law, Chapter 152, Section 17A, and we are merely relying upon this court's statutory interpretation and prior case law, which does allow you to review. Typically, the reviewing board is considered the trial court, but because the trial court summarily affirmed that, I also understand I have a higher burden because they did not author a decision, but that does not alter my position that they were incorrect.
Well, we review for whether the hearing examiner's decision was arbitrary and capricious. Is that correct? And ultimately, doesn't the case turn on his assessment of what were the causes for the? No one's disputing that the employee in this case was injured. Let's call it. The dispute turns on what role, if any, did his prior medical conditions play in that ultimate condition. Is that correct?
That is partially correct. I would supplement that with that the reviewing board decision was defective in that the administrative judge is required under those circumstances to make specific factual findings in support or non-support of Chapter 152, Section 17A, and those do not appear in the decision.
Do you think it's sufficient for the administrative judge? I'm sorry, I just keep calling him hearing examiner, but it's administrative judge, to identify the portions of the expert's testimony or reports that he credited? Is that sufficient to constitute the required finding? In other words, if he says Dr. X said Y and I credit that, is that enough to constitute a finding on the point?
I would suggest that it's absolutely clear that that's insufficient. I believe this court gives great deference to administrative bodies and their interpretation. And the reviewing board has repeatedly indicated that in an instance like this, where 17A is at issue, there is absolutely required findings to support any decision relative to causality. So there were no.
Why aren't those findings though? When he says what he made a credibility determination about, in other words, he says, I credit the cat was on the roof. Why isn't that a finding? You know, we see this all the time. A judge will say, I credit witness Smith's testimony that the cat was on the roof. And we understand that as a finding that the cat was on the roof. Why is that not sufficient in this case when the administrative judge used that type of formulation with respect to the medical evidence?
It's insufficient because the case law says it's insufficient. It says that you cannot do what this judge did. You need to look, first of all, I cited in my brief the case of Dorsey versus Globe Newspaper Company. That's a reviewing board case which indicates that when there are multiple conditions involved in 17A, you need to look at each of those conditions and make a determination of one, whether they combined, two, whether they were non-industrial, and three, whether the industrial accident remains a major cause of the employee's disability and need for treatment. I'm troubled in this case in that I raised two specific pre-existing conditions. I raised bilateral degenerative disease, which appeared in the medical records, and I raised obesity. In reading a hearing decision, I think it's imperative that one should be able to determine what thought process went into the decision. The word obese or obesity never appears within this decision.
Except that, say at paragraph 22 of the amended decision of the administrative law judge, which is at volume 2, page 257 of the record appendix, he says, Dr. Whitelaw opined that the employee had no significant history of injury or treatment with respect to his right knee until the March 2014 work incident. I adopt this opinion and so find. So why don't we take that as the administrative law judge finding that prior to 2014, whatever issues there may have been with regard to obesity or degenerative disease were not significant history prior to March of 2014? Why isn't that a finding of fact that we're bound by?
Because that's a misunderstanding of the statute. The statute isn't looking back. The statute is looking precisely at the point of contact when the alleged industrial accident occurs. So the fact that he may, and the insurer would dispute that fact as well, because there was evidence that he had complaints and treatment prior to 2014 for that knee. But the insurer would state that at the point of contact, obesity combined at that time. So it's like taking a snapshot when the industrial accident occurs.
So then what do you do with paragraph 34, which is on page 260 of volume 2 of that same record appendix, where the administrative law judge says, I have adopted the opinions of doctors Whitelaw and Superia that the March 2014 work injury is a major contributing cause of the employee's disability and need for treatment in the left and right knees. Why shouldn't we take that as a finding that obviates your point about obesity and degenerative disease?
You certainly could do that if you are going to disregard all of the case law. All of the case law at the reviewing board states that the judge is required to make explicit findings relative to the pre-existing conditions, because what anyone who litigates cases seeks is certainty. And in this court has held that once I have met my burden of production, the employee must meet their burden of proof. There is no way from reading this decision to determine whether or not the judge even considered obesity. And if you look at the report that you are citing to, so Dr. Whitelaw's report, there is no evidence that obesity was even considered by him. So again, I would go to, and I cited in my brief, the Cook case. The Cook case says if there are any factual omissions, it's not an instance going to the weight of the evidence. So it's not like, oh, maybe the judge can disregard, think less of it. It says it has no value.
But
So that report has no value.
You would agree that the judge considered and in fact found that the employee had pre-existing degenerative arthritis in his knee.
I don't know that that's
well.
accurate.
I can read you the passages if you want. I mean, we can spend our time doing that, but he does.
No, I don't want to.
He does find that.
Correct, but there's no analysis whether it combined, and there's no analysis.
Well, why isn't that to be inferred from the fact that the judge does not find that the work injury is the sole cause of his knee injury, but rather a major contributing cause? I mean, just the use of the term major and contributing cause necessarily means that there are other causes.
Correct. And I think that in that this is an affirmative defense, if the other causes have been articulated by the insurer and the insurer has met their burden of production, I don't think that it's asking that much for the administrative judge to comport with the standing law, which states that there must be exquisite detail in determining whether it remains a major cause. If we are just going to jump to conclusions.
Okay, so in your view, the remedy, I take it, would be that we would remand for supplemental findings about obesity, but given that the judge's finding is not that the work injury was the sole cause, I'm not quite sure why the additional findings would make a difference.
Because there was a great deal of discussion and medical evidence concerning the obesity, which was actually addressed by both the impartial examiner and the insurer's medical experts. So again, I would cite to the Dorsey case says that you have to look at each and every condition when determining whether 17A applies, which is the other flaw I find in the decision. The judge never writes whether it applies. Again, yes, can we surmise? I'm assuming he considered that, but it does not appear that that the insurer met their burden of production. And I'm more concerned that the trend of both the hearing decisions and the reviewing board of making a determination that if the insurer's burden of production is not accepted into evidence, that they don't consider it. And I think that's what occurred in this case. And I think that's reversible error, because there's absolutely no consideration to the insurer's position that obesity was a major, if not the cause of his need for disability and treatment. So
well, the examiners determined that it wasn't the cause, and the judge adopted the examiner's determination. The examiners determined that it was a major contributing cause was the injury of March of 2014. The IME, he wasn't aware of the injury of 2007. Is that right?
When you say IME, the impartial examiner?
Yes.
The impartial examiner, I don't believe, because when the case went to the impartial examiner initially, there was only one case in dispute, so there had been no other cases joined. At the time of hearing, there was the 2007 case was joined. So yes, to answer your question.
And so the impartial medical examiner didn't consider anything about the 2007, but the other examiners did indeed talk about the 2014 being the major contributing factor. And the judge, he points to 17A in his decision. He adopts the findings of the other doctors. So I guess by virtue of him adopting that, we know that obesity wasn't, as Justice Wolohojian pointed out, the sole factor. Do you agree
And
with
I'm
that?
not saying that I'm not saying that it is the sole factor, but I disagree with your premise. Anyone can say it's a major cause if they have not considered all of the pre-existing conditions. All the insurer is requesting is that when it raises an affirmative defense, that the administrative judge be required, as the case law says, to examine each of the pre-existing conditions and determine whether, one, they combined, and two, as a result of that combination, whether the industrial accident remains a major cause. No matter what has been adopted by the judge, there is no evidence from the employees, providers, or from the judge that obesity was ever considered. And that is patently unfair.
So how would the outcome be any different if he said obesity is considered, however, I still find that the major contributing cause was the injury of 2014?
If he went through the actual analysis and said obesity was a condition, I considered it, it combined, but the industrial accident remains a major cause, and there's a medical opinion to support that, which there is not, then yes, the outcome would not change. But there's no medical opinion to support that combination.
I think we understand your argument. Let me see if there are any further questions. Seeing none, thank you. We'll now hear from Attorney Hambleton.
Good afternoon. We're now in the afternoon, Your Honors. My name is Attorney Karen Hambleton, and I represent the employee, Paul Breen, the appellee in this matter. First, Your Honors, I would like to just comment on one aspect that Attorney Houston mentioned, which was about the evidence that was accepted by Judge Barrett at the hearing level. All the records were accepted by the judge. Those are evidenced at the beginning of his hearing decision when he lists all the evidence that he considered. And it's longstanding acceptable practice that as long as the judge lists every piece of evidence that he has accepted in as part of the record, he does not need to comment on every single piece of evidence. So the judge was well within his rights and did perform a proper analysis when he listed all the evidence that was offered in this matter.
Does the record on appeal contain all the evidence that was presented to the administrative judge?
I believe it does. I have not checked for every single, but when I went through, I was not the trial attorney, so I apologize on that, but I believe everything is there. I certainly checked what was referenced in the briefs and specifically the deposition.
Well, for example, in volume 2, what I see is exhibit 2, 3, 4, and 7. So that's not sequential, like 1, 5, 6.
I am not able to comment about whether every single piece of evidence is there. But in the context of the judge's decision, it's clear that he had received everything. So in our view, Your Honor, this is really a situation where the self-insurer disagrees with the decision, but the decision itself is well-written, well-reasoned, and not arbitrary or capricious or contrary to law. This is a gentleman who worked many years, as I'm sure you're aware, at the Massport facility, very arduous, laboring type of condition. Judge Barrett did find that the employee had testified credibly regarding the events in 2007 and thereafter. Credibility findings are the exclusive provenance of the trial judge, and it would be our position they may not be disturbed on appeal, according to Ledich's case. He did move through the events of 2007. He found that there was a work injury of February 15th of 2007 when the employee was at work and slipped on ice and wrenched his left knee. There were stipulations by the parties that the employee had lost considerable time from work and had returned to work full duty following the February of 2007 work injury. Then the judge moved on and did find that an injury occurred on March 30th of 2014, and that was the underlying basis for the claim that came before him. Again, he credited and accepted the employee's testimony that he left work in April of 2014 because of pain in both knees, that he felt like a cripple at that point. He then returned to work in August of 2014. And again, the judge credited the employee's testimony that the pain in his left knee was terrible and his symptoms worsened up to the time he left work in April of 2015. The parties stipulated, again, and Judge Barrett found that the employee had injured his knee in 2007. There was a second date of injury that was joined to the proceedings of May 18th of 2009. The judge did not find that a specific injury had occurred on that date, that there was no new incident, but that the employee had continued to work with pain. And then he found that the employee had injured both knees on March 30th of 2014. He allowed extensive medical evidence into the record offered by both parties upon a finding that the Section 11A report and opinion of Dr. James Bono, the court-appointed doctor, the so-called impartial doctor, was inadequate and the medical issues were complex. And those are the two grounds for opening the medical record in Section 11A. So the self-insured had the opportunity and did offer extensive medical records, did offer records from treating physicians going back to 2004 and 2005. And of course, then the employee offered his own records for examinations that occurred after the 2007 date of injury, and again, up through and following the 2014 date of injury. The judge reviewed all of this evidence, and then it's, as you correctly pointed out, he did break down his findings under the required statute, the affirmative defense of Section 17A. And he specifically adopted the opinions, as you've noted, of the employee's treating physician, Dr. Cornack, who diagnosed a work injury of March 30th of 2014, had caused, quote, a traumatic aggravation of severe medial compartment arthritis of both knees, left greater than right. He adopted the opinion, he cited the opinion of Dr. Glickman, the employee's primary care physician, of May 13th of 2015, who noted the employee's bilateral knee pain and symptoms worsened after the March 30th of 2014 work injury, and the employee had, quote unquote, retired from Massport because the knees were bothering him too much and he couldn't continue. The opinion expressed by Dr. Glickman was the work injury of March 30th of 2014 had caused a traumatic aggravation of severe medial compartment degenerative disc disease to both knees, left greater than right. So right there, you have the judge considering the pre-existing condition of degenerative joint disease. And that satisfies the first prong of the required analysis under the Vieira case for Section 17A.
Counsel, I have a question. Can we tell from the medical records whether the judge considered if perhaps the knee injury caused the obesity to get worse, or whether it was the other way around?
In the deposition of Dr. Bono, and I'm sorry, I cannot cite to the specific page, but in that deposition, Employees Counsel, I believe, did ask Dr. Bono that very question, Your Honor. And if I remember it right, and I was reviewing it prior to this, I'm not sure he rendered a definite opinion one way or the other. But what I think
But that's a fact-finding issue for the judge to determine whether the obesity was the chicken or the egg or the major contributing cause, as opposed to the knees.
Well, I don't think that the judge has to decide whether obesity or any pre-existing condition is a trigger or not. They simply have to find whether the work injury is a major cause of any ongoing disability. Now, there can be several factors that play in, and I think that's what we have going on here, that in and of itself becomes the pre-existing condition. So you had a prior work injury in 2007 to the left knee. You had documented obesity. You had an injury of 2014, of March of 2014, and you had the both Dr. Bono, the court-appointed doctor, and the self-insurers expert talking about obesity and the load on the knees. And in addition, Dr. Bono at the deposition was asked and agreed that the continual load of the employee's work activities on his knees also furthered or played a role in the subsequent disability. So the judge, in my view, did consider all these factors as an umbrella of pre-existing conditions, and that he is not necessarily required to go through every piece of evidence and comment on all the evidence regarding whatever pre-existing conditions, what roles they play in this. Instead, the judge has an obligation, which he fulfilled, to consider the Section 17A argument, the role that the pre-existing conditions, whether that's a prior work injury, whether that's obesity, whether that's load on the knees because of the employee's arduous activities at work. He did consider all those, and those are all factored into his findings and adoption of the opinions of the treating physician, Dr. Cornack, that he had a traumatic aggravation of the underlying, the opinions of Dr. Superior and Dr. Whitelaw that completely acknowledged that he had a pre-existing arthritic condition to his knees. And they both, Dr. Whitelaw and Dr. Superior, both provided the opinions that the judge could rely upon and did properly rely upon, that the work injury remains a major cause in combination with pre-existing non-work related conditions of the ongoing disability and need for treatment.
I think we understand your argument. Let me see if there are any further questions. I think we've got it, unless you have anything further to add.
No, Your Honor, we would just request that the review board summary affirmation and the judge's decision be affirmed. I think reversal would be a harsh result. I don't think it's required in this matter. And your point that sending it back for further findings specifically on obesity in all likelihood isn't going to change the outcome because the judge made sufficient findings regarding any underlying pre-existing conditions.
Thank you. We appreciate both of your arguments. They've been helpful to us, and the case is submitted. Thank you very much.
Thank you.
Yourself, and then we'll get going.
All right, we are live and recording.
Good afternoon. Welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this fashion due to the ongoing pandemic. Although we are conducting court in this way, all the ordinary rules of our court apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of in the matter of the Colecchia Family Irrevocable Trust, case number 2020 P0224. And Attorney Wells, we're ready whenever you are.
Thank you, Your Honor. I'm ready. If it may please the court, there are three issues here on appeal. The first one I'll start with is the dismissal for lack of service. And the court, I think, erred factually and legally on that. The record shows that the citation was returned as required. There was a citation required it to be published. It was published, it was returned, service was made. In addition, my brother had waived service. They agreed to accept service on behalf of the trust, and that's not in dispute. And furthermore, under Rule 12, you have to, that's one of the defenses that has to be asserted in the first pleading, and it was not. So there are multiple grounds to find that service here was accepted. The parties went through and litigated for 2 years.
Well, you don't dispute that you didn't provide service on interested parties, all interested parties. Is that correct?
No, because the order provided an option. It said and or, and I did the citation. I published the citation as the option.
You did publication notice, but you didn't do any other kind of service. Is that correct?
I did all service on everyone except formal service. The one party who knew about and had knowledge of the case. So no, I did service through publication, which was what the citation required.
Right, but what do we do about the fact that the judge determined that the rules require something more than that?
The rules state that it's subject to the judge's order, and the judge's citation, issuing a citation, is in effect an order. And I think we respect the citation over the rule because it's a judge's act. And in addition, the statute also allows, it gives an alternative too. So the rules, they require more. However, it's not violating the statute, which says service may be done by publication or in hand or etc. So that, I think, is how you look at it. If a citation is issued, the judge issues an order and have authority to issue it and it's respected. I think that it's unfair to penalize a party or to find an act wasn't done.
Was there more than one citation?
Yes, there was.
So which one are you relying on?
The second one.
Can we look at it in the record, please? What page?
Sure. Excuse me, let me.
Is it the one on page 121?
That's right. No, it's not, it is that one. That one was amended later, but this is the one that was returned. I went to court during the hearing that the judge wanted me to.
Right, so this was the one that there was a later one after this, correct?
And it's the same citation.
But where is the later one in the record? Because I think what you're talking about is it's the portion of the citation that's the order of notice.
Perhaps page 132 of the record.
That's right, yes.
Okay, and you're relying on the and/or language?
That's right, yes.
Okay, at some point the judge told you that was not, publication notice was not sufficient.
No, only by dismissing it. It wasn't, I mean, I wouldn't, if the judge had brought it up, I would have served it via mail. I believe the brother in question had a copy. It just wasn't formally served. And it wouldn't have been a problem. I'd just followed through. And I also think that the trust, because it's representing the brother as the trustee, that service on the trust and its ability to waive service applies to that sufficient service for him. The trustees combined the beneficiary, and under the Uniform Trust Act, a person who combined a representative or an agent, principal, a beneficiary, they service on them and their waiver of service is sufficient to satisfy service, which is a separate legal argument too.
Well, that would extend only to the parties whose agent was authorized to waive service, correct?
No, sorry, I didn't explain that well. The trustees represented the interests of the beneficiaries. That's their duties. So by accepting service, the trustees accepted service, they have the ability to bind and accept service on behalf of all of the beneficiaries.
What would be your legal authority for that?
It's Uniform Trust Act. I believe it's the first portion here. I can give you the exact one. So chapter 203E, and it's either Article 1 or 2. Okay, so I thought I can provide that. I thought I remembered exactly where it was, but there is that authority in statutory, and I can file if you want that statute right after, where it basically, I mean, it's similar to why you have trustees in the first place. It's a efficiency mechanism that they're serving and handling this property in benefit of other people.
But you're telling us there's a provision specifically in the Uniform Trust Act that says that when an agent of the trustee, such as an attorney of the trustees, agrees to accept service, that constitutes adequate service on the beneficiaries of the trust as well.
That may bind and that do not have a conflict. That's right.
All right. What counts does this argument you're making pertain to? Because at this point, we're talking only about counts. I want to make sure I'm right. It's only the count 2, correct?
This argument applies to all counts. The entire petition was dismissed.
Right, but before then, hadn't certain counts been dismissed under a motion for judgment on the pleadings?
That is right. I don't know if that's effective if there's no service, but yes, that's right. So
the issue of the service was not raised until afterwards, correct? by
That's right.
after some of these counts had already been dismissed.
That's right.
Was the motion to dismiss for failure to effectuate service filed after those other counts had already been dismissed?
That's right. Yes.
So it would only pertain to the undismissed counts?
Yes. If it's going to be limited, yes, I suppose.
Because some of the other ones had already been dismissed. So, right?
I would assume that lack of service would apply to the entire petition. I mean, it's just it's peculiar, but if you don't serve some counts, I don't see how it wouldn't apply to the other counts.
Okay, but those some other counts had already been dismissed.
That's absolutely right. Yes.
Okay, so which counts were remaining after the dismissal on the motion for judgment on the pleadings?
2 and 3.
2 and 3. So did the motion to dismiss for failure to service, when it was filed, did it apply only to counts 2 and 3?
I mean, they're the only ones that existed. In that sense, yes.
Okay, so I take it that if we were to agree with you that the judge erred in allowing the motion to dismiss on the grounds that service was inadequate, then that would, then reversing that would only pertain to counts 2 and 3. We would still need to assess the dismissal of the other counts.
That's
on
right.
Merits.
Yes, absolutely.
Only part of count 3, right? Wasn't part of count 3 dismissed on the pleadings as well?
It was a partial, yes, and I didn't really understand how. Yes, it was limited.
Can you tell me, I must admit, I'm completely unfamiliar with this mechanism of the general petition. Can you explain to me why you filed a general petition as opposed to, for example, I mean, essentially most of the claims here fall under the rubric of breach of fiduciary duty. Why would you not just file a complaint alleging breach of fiduciary duty?
Under the statute, one of the counts required a petition, and I filed a petition because the statute required it.
Which statute is that?
I believe it's either the Uniform Trust Act or one of the previous procedural acts there, but there is a section that requires any petition to invalidate a trust to be done through petition, and as a result, I joined the other claims under supplemental jurisdiction.
Okay, so that answers my question. It wasn't that you're seeking to invalidate the trust.
That's an alternative, yes.
Okay,
right.
That's why you need the general petition?
Right.
And that's a form of relief that you were seeking in response to which of these counts?
That would be the undue influence one, would have invalidated the trust.
Okay.
Okay, I'll proceed, and I have a minute and a half. I'll go over quickly. The main issue is whether there was the trustees owed a duty to beneficiaries. In 2005, the trustees were conveyed the property wholly and fee simple. Position is that the trust was created. The property was being worked on, had been worked on by my client, and he continued to work on it for the next 12 years. The trustees knew that he would not work on it if that he was informed of the trust. And they also benefited because they had a higher percentage of the payout under the terms of the trust. Now, our position is that a trustee, this is for one, self-dealing, and two, a trustee has a duty to tell the beneficiary, inform full disclosure that, hey, what you're doing now is not, it's no longer owned by your parents, it's owned by us in fee, with a leasehold to the grantors. And it's a leasehold because the right to collect rents was not allowed, and it was optional. The grantors, if they moved away, they no longer had any interest in it, and a life estate is more permanent.
Counsel, I have a question.
Yes.
From the record, do we know anything about why the parents decided to allocate the shares so that each of the three daughters got 23 1/3% and each of the sons got 10%? And related to that, do we know if any of the daughters might have had some sort of quantum merit claims for services they performed for the parents?
On the first question, no, we don't know that. We don't know why. It was the other trust instruments, or the other estate instruments, I should say, split everything equally among among all six. And in regard to the quantum merit, no, I don't think we know for sure, but I think that one of the daughters did more work than the other two daughters, and probably did the equivalent work of my client, just in a different form. My client did the outside, the yard work, the shoveling, redoing the bathroom, and I understand that she managed certain affairs, Denise, in the last few years. So she potentially may have a quantum merit, but that's never been developed, and I'm just kind of given a broad view.
Thank you. Are there any other questions? All right, thank you. We'll hear from Attorney Ricciardelli, please.
Thank you.
Thank you, Your Honor. May it please the court. I would first just like to address the timing of the appeal is the first issue that I'd like to address. Under Rule 54B, it's required that before appeal is filed, the time starts running on the appeal after a final judgment is entered. Final judgment would be something that disposes of all claims unless the court, in their order, indicates there's no reason to delay in filing the appeal, which this court did not. If you look at the court's judgments, the first judgment in October dismissed of counts 1, 4, 5, and 6 of the 6 counts, and partially dismissed count 3, basically limiting it to any time after the death of Lillian Colecchia on February 27, 2016. Subsequent to that, the court then dismissed dismissed for lack of prosecution, but also dismissed the judgment for count 2 of the complaint as amended. If you look at the first order, which was actually the second order, but the first order regarding the remaining 2 counts was on March 8th, and it only indicated a judgment of dismissal of count 2 as amended should enter. It was then filed, what was labeled by myself, I filed a motion to amend. Now, the motion to amend was only done, I actually filed a motion to clarify initially, but the clerk would not allow me to file it in that fashion. Only a motion to amend could be filed. The idea behind that was that it appeared that the court may have made an error in only dismissing counts 2. Based on the notation put on my actual motion, I was unclear whether the judge intended all counts or not. So I filed the motion to amend, which was actually a motion to clarify. And the judge subsequently on May 8th dismissed the final count. That would be the day typically that the 30-day period would start to run. However, I then filed a motion to amend that judgment for leave of court to allow for attorney's fees, which the judge then again allowed. That is still going on. This case has not left the probate court. We had an evidentiary hearing scheduled on the attorney's fees because my brother requested an evidentiary hearing. That was scheduled for March 30th 2020, but because of the pandemic was delayed. And we had a Zoom hearing in November of 2020, where I requested the court decide on the pleadings, the issue, but we have not yet heard from Judge Elwick on that issue. So as of today, this action is still in the lower court, does not belong in the appeals court. Nonetheless, I believe that the matter should be dismissed for that and for the other reasons indicated in my brief. Specifically, on the lack of prosecution, I would just like to add to the court on the citation. First of all, I
misunderstood something from your brief. I'm sorry. I thought that the reason why you were arguing that there was not a final judgment was because of the, I'll call it the post-death piece of count 3. But the judgment, I take it, has actually entered on that piece of count 3. Is that correct?
It did enter, but not until May 8th. The appeal was March 20th.
Okay,
so that initial appeal was on an order that was not a final judgment.
Yep.
It is now entered, but because of the leave of court, to grant me leave of court in order to file a motion for attorney's fees, which I've now done, that the action is still pending. There's no final determination on attorney's fees as of yet. So therefore, this matter isn't right for
okay, so I take it one part of your argument is that the notice of appeal was premature because there was no final judgment on count 3 when it was filed. And the second piece is that given your motion to amend the judgment to include fees, there's been no final judgment at all.
As of this date, correct, Your Honor. Correct.
Okay, did you file a motion to dismiss in this court?
I did not, Your Honor.
Did you file a motion to dismiss appeal down below?
I did not.
Okay.
On the second matter, on the lack of prosecution dismissal, if I can just add that in looking at the citation, I know my brother indicates that his belief is that publication was sufficient. If you look at his citation on page 134, his return, I should say, on the citation, it says by publishing once in the Lynn Gazette on, and he doesn't put a date in. First of all, the Lynn Gazette is no such newspaper. It's the Lynn Daily Item is the only Lynn newspaper. And it says on a particular date, which was at least 7 days before the return day. He didn't fill that in. So how we can determine it was 7 days before the return day. So the return wasn't even properly completed when filed. And that was done I filed that motion to dismiss with the court only because the clerk would not set a pretrial date unless the return was filed with the court. So I filed the motion to force my brother to file that return. And when it was filed, it was then discovered that it wasn't served properly.
Is your contention that publication alone is insufficient despite the language of the notice order that says and/or?
Yes, my interpretation of the and/or is that it's to the court. It allows the court to make that determination of the or. If you're unable to serve the person, you have to show that the person cannot be served, and that would be sufficient. I don't take that.
Where do we get that from? Is there a legal authority to that effect? A case?
No, I have no particular case to draw off of for that authority. That's how I've always practiced and how I've always considered it in my practice. And again, I believe that I pushed for this case to be heard on the merits in the lower court, even despite the dismissal, because my belief is that the case should be dismissed on the merits, and to dismiss it based solely off of the lack of prosecution would not allow us to get to the merits. And that's why I only filed the motion to dismiss, to get the citation served. I wanted to get to the merits of this action. And obviously the judge agreed with me, because the judge then went forward and said, even if it weren't dismissed for lack of prosecution, it should be dismissed on the merits. So the judge did consider everything on the merits and still elected to dismiss.
So was your motion to dismiss for lack of prosecution filed before the judge ruled on the motion for judgment on the pleadings?
On the second motion for judgment on the pleadings, it was after the judge ruled on the first motion for judgment on the pleadings that dismiss counts. So my brother was right, that counts 2 and partial limited to count 3 was still a viable actions at the time.
So at that point, when you filed your motion to dismiss, it pertained only to counts 2 and the remaining portion of count 3?
Well, theoretically, but as I said, I only filed the motion to dismiss to get the return filed so I could get a pretrial date. So it was really a procedural matter that the clerk wouldn't, I had no mechanism to force it without indicating that I would like it to be dismissed, assuming it would then be filed and the dismissal would be denied.
Okay, so what I'm really trying to get at is that when you filed the motion to dismiss for lack of prosecution, it really pertained only to the counts that had survived the earlier dismissal on their merits. Am I correct?
Well, since they're the only ones remaining, yes. However, I would imagine if for whatever reason those were revitalized, the lack of prosecution would serve to dismiss the original, the petition in its entirety. I agree with my brother in that regard, that I don't know how you get around that despite the fact that the counts were already dismissed, that the lack of prosecution on the entire, and the lack of service on the entire petition, how you get around that dismisses the entire complaint.
What is, apart from your own customary practice, what is your best legal authority? By that I mean a case, a rule, something that that indicates that when the notice order says service can be made by personal service and or publication, that the and or means both.
What I mean, I have, like I said, I have no rule or case law off the top of my head. Again, it's my own practice. The statement and or to believe that it's us that decides and or, it doesn't make any sense to me. In other words, if the judge orders, if the order says and or, I assume it might have, the judge would cross out one if the judge intended to do so. But I always err on the side of and being the operative terminology. If you know where someone is located, because if you look at the 14-day, the indication that you have to serve them by mail, it does say interested persons, if whereabouts known. And that's, to me, while the and or is there, is because if they're not known, then that would be an option to just publish in the newspaper, but you'd have to get the court authority on that. And that's, again, that's just something for me as a practice that I've always done. And the general practice, I think, around all probate lawyers is to just serve everybody and anybody, because then you're safe. But the requirement, no. And as I said, again, I wasn't that interested in having the judge dismiss this case. I wanted it to be heard on the merits, because if we dismissed it and then it was filed again, it would just back to square one.
So did you have another, at that point, when you filed this motion essentially to try to get the case in front of the judge, did you have at that point pending another motion, or were you seeking to get the case tried, or were you seeking to have the judge consider another dispositive motion?
At the same time, I filed the motion for judgment on the pleadings for the remaining 2 counts. And I did that, but obviously I wanted the motion to dismiss was if the judge decided not to dismiss those 2 counts, please schedule a pretrial so we can move this along.
Okay, and was the motion for judgment on the pleadings for counts 2 and the remaining portion of count 3, were those acted on?
Yes, they were dismissed. As I indicated, they were dismissed. First, the judge dismissed only count 2, but through my subsequent motion, bringing the error, it was apparently a typographical error, because the judge then filed in May 8th, entered another judgment, what I call the final judgment, which added count 3.
But my question was not clear. That dismissal was based on the procedural ground of service, correct?
No, it's based on both. If you look at the dismissal, it says the judgment dated March 8th says it's dismissed for lack of prosecution, and then states even were the matter not dismissed for failure to comply with supplemental probate court rule, a judgment of dismissal of count 2 of the complaint as amended should enter. And then it referred to my motion for judgment on the pleadings. And when I went to when you look at my motion for judgment on the pleadings, the judge made a reference that it was allowed. I asked for all count to be dismissed. So I brought that to the attention of the judge, who then entered an identical judgment on May 8th, but only adding count 3 should be dismissed as well. That was the dispositive judgment, in my opinion, at least until I filed the motion to amend.
Okay, thank you. I think I now understand.
I have a few questions about the service issues. As I understand it, so Mario is the brother who lives in Florida.
Yes, he's now
And
deceased.
Okay, well, and Mark is the brother who sometimes doesn't have an address, or his address is unknown.
Yes, that's my understanding.
So, and those are the two who we're not sure if there was service on them, or it appears there was no service on them. Is that right?
Correct. Correct.
So why wouldn't the judge refer to Probate and Family Court Rule 6, and Rule 6D talks about service outside the Commonwealth, and it says it shall be made by delivering in hand or mailing. So that would be Mario, and then E is service when whereabouts unknown, and it says it shall be given by delivery to the last known address. And I take it neither of those things was done here. Is that right?
That's right. According to the return, they weren't done.
So as I understand it, your brother's argument is resting on an assumption that that use of and or in an order of something published by the court superseded the shall requirements of these rules.
I assume that's what his argument is. I mean, that you'd have to ask him specifically what his intentions are, but that's what sounds like what he said today.
But it was the judge, it was the probate judge, who's Judge Ulwick, who was in a position to decide whether or not it was these parts of the rules that applied, Rule 6, or whether that and or somehow absolved Mike from complying with those rules, right?
Yes, it was completely the judge's determination, and I didn't request specifically that. I wanted it to be filed with the court. That's all.
Okay, thank you.
And again, I can see my time has expired, and I'll rest on my brief regarding the merits, because I do wish that want this matter to be determined on the merits, because I don't think if you look at all the counts, I don't think they've pled a case that should be going forward. Almost all of the damages indicated here are based upon work done at the property. And to say at the property, it's mostly landscaping and snow removal. And then there was an indication of a bathroom being renovated. The bathroom was being renovated, according to the pleadings, because Mr. Kaleckia had difficulty getting into the shower. So it wasn't renovated out of need in the sense of the property, but need in the sense of Mario Kaleckia. And they had a life estate on the property. With the life estate comes the obligation to pay for repairs and maintenance on the property.
Your time is expired. I think we're going to have to leave it there.
Okay, Your Honor. Very well. I'll rest with, you can see in my brief, I make the similar arguments.
Exactly. We have your briefs and we've read them carefully. Thank you both. It's an interesting case. We've been helped by your arguments, and the case is submitted.
Thank you, Your Honor.